Is your information right?
Yep.
Okay, so this is the first casual conference I'm going to.
Yeah, they're good to go to.
Yeah, it seems like it would be. Is this for us or do you want this back?
Oh, you can have that.
Cool, thank you.
You're welcome. Plus the Casio things are affordable too, because you usually get a lunch out of the deal.
Yes, it's at Water Ridge.
Ooh, I went to the one, they had one on the Sound. That was the last one I went to before COVID, was down on Long Island. What's that hotel in Madison or whatever, it's on the water.
Yeah. Nice.
It was nice, it's a nice excuse.
Water's Edge.
No,
Water's
not
Edge.
Water's
That's
Edge.
Water.
Yeah, Water's Edge is nice. I've been there for weddings and
Yeah.
stuff.
It's just like a little hotel,
Oh.
and it has a little bit of beach there and stuff, so the room they put you in, of course, you can look out on
On the water. But they got a pretty good, big rooms for doing, cause I've been there for even like, Easter brunch, I think even.
Yeah, yeah.
I've been
Look
there,
that
my
way.
cousin's wedding was there.
You go in, there's a nice room, and then, yeah, you see the big rooms off of that, and then we went upstairs, there's smaller rooms
Yeah,
upstairs.
smaller ones, yeah.
Well, like this size maybe, but,
Yeah, and the beach isn't too big, but I mean, the back patio and everything else.
Oh,
is
it's
pretty
nice,
Yeah.
nice view, and,
No, I didn't see Google it today and I didn't.
Why, who's going there?
Nobody.
Oh, I thought maybe we were gonna have
Talking
a
about-
meeting there or something.
do our next workshop there.
Wow, that'd be something.
Yeah. With Watch for Our Flyer, I think we're gonna do it. It's usually in March. We do it's with the Connecticut Federation of Planning and Zoning Agencies. So we had to cancel the last 2 years because of the
I would love to go to
COVID
that.
stuff. We do it the AquaTurf. You guys always go.
Yeah,
Southbury's always would
Okay.
send.
yeah, I mean, that's one of the line items
Yep.
in the
So I
budget.
think we're talking about it, and it looks like this latest variant's not so much of a big deal.
Yeah.
So.
Good.
So if the AquaTurf will do it, then
Great.
yeah.
So I'm gonna hit the thing.
So whenever you're ready, I think you have to still call to order.
So this is actually a formal meeting then?
Oh yeah.
Yeah, because everybody's together, but it's a workshop training meeting.
Okay. All right, like, good.
Yeah, the live stream is on. It's on the red light blinking.
I'd like to call order on December 7th, 2021, approximately 7:09 PM. I'd like to stand for the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. All right, so I guess the first thing is the seating of the alternates. I don't have the actual,
John Allen Jr. is our alternate.
okay. And is there just one? I thought we had two.
Kathy, are you an alternate or are you a full member?
Member,
She's a full member.
Board of
So
Appeals,
it's
this
just,
is, right?
excuse me?
Board of Appeals.
Yeah,
Correct.
Yeah.
zoning board of appeals, full member.
All right. So how many positions do we have open, or if we only have one alternate, that means we're short one alternate, right?
Keeping track of.
Because Tom is done, correct? Yeah. Yeah, he resigned, so he's no longer after tonight, okay.
Oh, he resigned? He quit?
He's been talking about it for quite some
Was
time.
he moving, I thought?
He's
or
moving?
I don't know.
All right, so we just
Is he
need,
part of his
there's,
son's
No,
died
they're
or
all
something?
here.
Oh,
Yeah,
I hope not. No,
no,
I
Carl's
don't think
not.
so.
What's his last name?
Petrini?
I don't know.
I was down to seat your alternate.
do we need to seat an alternate? I mean.
Not really, there's no
yeah.
voting.
There's not
Yeah.
gonna be any
Yeah, there's
business.
not any business, so I don't think so. So we're just short one alternate that wasn't elected to take that position,
Okay,
correct?
is that on the Republican side or the Democratic
A
side?
Republican.
So we need,
I don't know until I get the report. I don't know that that's.
Port
yes, it
River.
is, yes, it is. Because if it's on the Republican side, I have to be the one to go get one.
Oh,
If it's on the
you mean
Democratic
not that
side,
they're not here, just.
No, like you worked
Okay.
with the clerk on that.
yeah, oh, yeah, yeah. So, okay, all right.
So I guess we can start the training workshop, which consists of a special meeting of a staff, and I'm sorry, I didn't get your name fully.
Stephen Byrne, so it's,
Okay,
thanks for having me.
and how are we gonna go about doing this? I mean, as far as,
Usually I just go through, you guys have some materials, so I'll kinda just go through that quickly, and then we can try to touch on, being a ZBA, usually your questions are gonna be, what's a unusual hardship and that kind of thing.
well, that would be good, yeah, 'cause
Yeah.
I do have quite a few questions on this, so I
Right.
didn't know if it would warrant to do this first, or do questions first, or how would you wanna?
Usually I go through these first, you could even get other questions you didn't think you had, so,
Okay.
Yep.
Mr. Chair, can we introduce everybody?
Oh, I'm sorry, yes.
That's all right.
I'd like to, yeah, that would be good, we can go around the table and introduce yourself.
Yes, I'm John Allen.
John Allen?
Yes.
I'm Mark Kane, nice to meet you.
Mark, nice.
David?
Steve, aren't you?
Kathy Fracasini.
I'm Mark Kane, nice to meet you. We know Steve Byrne, right?
Yeah, got it, good.
I'm Jessica Townsend, I'm the ladies administrator.
And I'm Ty Curran, I'm the enforcement officer.
Bonnie Rado, I'm administrative assistant for,
And
You're,
I'm Sharon Scarlett. I met you, Mr. Byrne. I've spoken to you on the phone many times about bills and amendments and things
Oh,
like
yes.
that.
Yeah,
Yeah, we've had
yeah,
some
yeah.
big conversations about
There's
that.
more bills on the way, so
Yeah,
we'll be
right.
talking and that stuff.
All right.
More in the gravy train with that stuff. Well, good, well, thanks for the introductions. So who's new, who's brand new to the ZBA?
I am.
All right, all right. Very good then, glad I'm here. So, been doing these workshops for like 30 years, but now there's a new state law that says you guys have to do workshops, so it's 4 hours of training every 2 years. Except that this first year, well, we're starting in 2022, we gotta get 4 year, gotta get 4, no, that's right, by 2024 you need to get the first 4 hours in, so. And it's supposed to touch on, not just what's in here, which is, how to run a public meeting or a public hearing, and also your roles and responsibilities as ZBA members, but we're all supposed to touch on, affordable housing and that, fair housing and that sort of thing. But what I thought for that is, we won't do that tonight, that's more maybe we could do together with planning and with zoning, get them all together for that. And for you guys, focus on just your roles as the ZBA, because, while the topic list is short, just when to grant a variance, and we could talk all night tonight, we could keep talking all week on that, what's an unusual hardship and that sort of thing, when you should and should not grant a variance, so. So with that being said, I was just gonna go through quickly though, what, you have a little brown booklet, I'd go through quick, and then we'll get to the zoning board of appeals stuff, the variance stuff.
can I just maybe ask a question that will help me through the whole process of going through this? It's
Sure.
kind of an important, I had a conversation with somebody today. But if you can't establish a hardship in the beginning of the application session, the meeting, the public hearing, should it continue any further, in essence, granted, they're gonna preside their information continuously through, but theoretically, when it comes down to the board making a decision, is it done in steps as far as, one, it has to meet this criteria, then you move to step 2, then you move to step 3, or is if there's another case of hardship, everything else from that point forward becomes, mute, it's really nonsense?
You could, offer guidance, if you will, like to the applicant, like tell them, here's what we're gonna need to see. We're gonna need you to show us that there is a valid hardship, why you deserve to get the variance. And then, of course, the second part is also that by granting you this variance, what you wanna do still fits in with the comprehensive plan, will still fit in, with, I guess we can't use character anymore, but it will be in harmony with the neighborhood. So you can offer that guidance to them. If they choose to ignore you and they forget hardship and they do a nice presentation and everything else, your role as a ZBA, it's their public hearing, let them say their piece, let them make their presentation as they wanna do it, and if that's how they do it, let them go. Don't try to,
You don't think you should
dictate
guide
too
them
much.
To
I-
say, this doesn't really,
I
point
guess
out.
you can offer like guidance in the beginning, what you need to see, but then if they choose to ignore you and they go on, you let them have their time.
All right, maybe, let me try to explain it another way. I understand exactly what you meant, but I'm saying under a decision-making, when we close the session and we're
yes.
looking at everything else, I understand they're gonna preside their whole case, but then when it comes to us making a decision, if it doesn't fit the criteria of being hardship, should anything after that, as far as, is it coming more into compliance? Is it, should it be knocked down? Is this gonna be, any of that taken after the fact of the point? Is there a hardship, period? If there's no hardship, we should really not explore anymore, but if there is, then we can move forward to the rest. Is that how it should be done? Because if there's no hardship, what's the purpose of continuing through the meeting?
Theoretically, I mean, an appeal could be taken to court, and then the judge could disagree with you and say, no, I think there was a hardship there.
But then it would get kicked back to us then. Then we'd have to go further.
You could, might be better to avoid that. It's called a remand, and what I would say is I would address both points no matter what. Say, we don't have a hardship, but we're also gonna look at that second issue, which is,
Okay, so
Yeah.
then in essence.
you're
how-
building the record is what I'm saying.
I understand that, but my point, and this is where I keep coming up with I don't wanna say a problem, but an issue is that, cause I've been in front of many ZBA boards for doing projects, and if there's no deal of hardship there, in essence, that's the whole purpose of coming before the board.
Right.
If it gets denied in the zoning, there's a hardship on why you wanna do this, but if there's no hardship, what difference does it make after that? There's really no point in continuing, because if somebody comes in here and says, oh, I just wanna do it because, I wanna put it on here and I don't wanna build another house, or whatever, and there's no real absolute reason. Why would you entertain anything, regardless, unless they could prove hardship? Why would that get the judge in turn? And I'm just trying to understand this so that as we go through this, I'm not thinking in my head, well,
Right.
there's nothing here. I wanna make sure that I'm going forward with this question I have answered. But if there's no hardship on anything, if you look at any of the regulations before this starts, on any meeting, you need to prove hardship in order to have this granted to you. If there's no hardship, who cares if you're making it more in compliance, even though it's still not compliant? That's irrelevant. There's no hardship here. And am I making?
You're making a point, because legally, like, if it got to, for a judge, is how a judge would decide. A judge would look at those 2 points of,
But then our job is really null and void then in that essence, because then if he's gonna override the fact that there's no hardship in our opinion of what we've based our opinion on, and moves to option 2, what's our voice then? Why are we even here then?
well, on
What
page
is option
17 of this
2?
booklet.
What is option 2?
Oh, option 2, I was gonna show you, is,
Oh,
because the first thing is, the variance, actually, it's funny with the state statute, it says, the variance must be
Is that
shown.
book right there, Jessica?
Oh, yeah,
No,
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 you
I-
do have it.
I emailed,
Oh,
those are extra ones I brought.
okay, thank you. All right, so
Yeah,
17.
plenty, page 17. Before you can grant a variance, there's 2 points, 2 conditions have to be met, which is the variance must be shown not to affect, substantially the comprehensive plan. And the second point's the hardship point. And the court sees those as equal. You need to satisfy both. So theoretically, you're absolutely right. If there's no hardship, you could end your discussion, take a vote, and turn them down. All I'm saying is, if it goes to court, it'd be better if you have addressed both. You don't want to get it sent back here and the judge may not send it back. The judge doesn't have to. The judge can then find on his or her own, you should have granted the variance. I find a hardship, and I'm gonna decide on this other issue too, and not let the board make a decision on it.
See, I didn't realize there was 2
Parts.
factors
yeah,
here.
let me
to it.
have
Yeah.
one too.
I thought it was basically, and even when I've gone in front of other towns and done projects where I've had to show hardship, I was always under the impression that you need to show your hardship. Can I have one for Sharon too, please?
She has one.
versions of the same.
Oh.
It just doesn't have a little color.
Yeah, see 17 on here,
Page 17?
on this other one.
Page number, it's up in the corner,
The
the
workshop
upper right.
page?
Yeah.
On here, yeah, but not on the other one.
So then under
It should
every,
be. Oh, yeah.
so under every
Okay.
application then, we have two variables that we have
Yes.
to take in, not just the one of hardship.
Because they could prove they have a hardship, but if it doesn't fit in with what they want to do, it doesn't fit in with the comprehensive plan, it's not in harmony with that neighborhood, you could still turn them down, and it's a
Correct.
necessary hardship, so.
Right.
Yeah, they're two equal parts, the court sees as two equal. I think, you know, in your experience, you know, they remind you of hardship. A lot of people skip over that. They'll present, look at this wonderful thing I want to do with my property. It's going to be great. And they kind of skip over that whole hardship argument. 'Cause-
Right, and I always
Probably don't have
thought
it.
first you had to definitely have a definitive hardship before you could even go forward. That's the way I've always taken it for years.
Yeah.
That when you go before the board, I have a legitimate hardship. You know, my family's grown, I've outgrown the house,
Mm-hmm.
you know, we like to stay in the town. And, you know, we wanna make and expand our house bigger, you know, and do whatever we need to stay in this town and everything else. There's a hardship, our family grew, you know,
But isn't that subjective, kind of what's the hardship?
it is,
Oh,
and
yes.
it's all a personal
Right.
opinion of it, that's why you have multiple
Yeah.
members. But my thought was, is that first you have to declare that hardship before you can even go any further, that's the way, and I just wanted to be clear, so basically what you're saying is also, they can go around the hardship in some essence, or do they still have to prove a hardship?
They have to prove both. They're equal parts, so they can do one before the other, prove one before the other, so.
But in essence, it boils down to hardship.
It normally does, yeah. But like I'm saying, it's still good to address both. You don't have to. You could turn them down on either one, I guess. You could say, sorry, you know, it doesn't fit in. What I'm saying, if it goes to court, I'd much rather have you
Address
touch on both, yeah.
Okay, all right.
Just to
You
back
cleared
up.
that for me, thank you. I didn't mean to it's just that as we go through this now, I don't wanna be sitting here, you know, I wanna raise my hand, you know what I mean? So at least now as we're going through, if there's anything on, I understand.
Right.
Thank you.
Not a problem. But, back to the brown, we'll just touch on this real quick. I just wanna let you know what's in here, in the brown covered pamphlet, which is just the first, let's see. It's pages 2 through 4, you know, guidelines for the conduct of a public meeting and a public hearing. And, just wanna point out just conflict of interest, if that ever comes up. And how to address that, if either, that's an issue, you know, if you think you might have a personal interest or a financial interest in an application before you, you know, you're friends with the applicant, or they're a relative, or a business partner, or something, you can disclose that yourself, and just say, I think I have a conflict here, I need to recuse myself, you know, get that on the record, and then you should really just leaving the room is the best thing, definitely leave the table. I've had some cases where board members, they stay in their seat, and you know, it's always from the perception of someone in the audience, how does it look, and it's not a good look, because you know, theoretically, you could still be exerting an influence on the other members just by being there, if they know that you're either strongly opposed or in favor of something. So it's better if you just step out for a while and then come back afterwards.
Now, what if the board member doesn't feel they wanna step out and wanna sit in the back of the room? Does the chairman have the right to, you know,
Kick
let's
him
use
out?
it for a lack of a better word, a demand that he does to?
No, it's really, as a chair, you would just direct the question, say if someone in the audience or the applicant says, I think I would want, you know, John to step aside, he's you know,
Okay.
he's hated me forever or something, so, you know, you would just then just direct it and try and get a response from that board member, and they should, on the record, say, no, I'm gonna not recuse myself, I think I can make a fair and open, you know, fair and open mind on this, so it's their decision alone
Okay.
to sit. So, and all they need is, to express they have an open mind, so even if, you know, it's an application for someone, you know, they wanna, you know, put a McDonald's or something, or and you're known to not like fast food restaurants, you don't want any fast food restaurants in Southbury, you know, you could still say, but my mind could be changed, and that's enough. So, as an attorney, I'd still rather have you err on that side of caution. If you have enough members to hear it, the better part of discretion would be to,
So it's up to the
Recuse yourself.
individual to.
it
recuse
really
himself?
is, and that's the end of it too, is that when that person says that, well, until it goes to court, I guess, but if that person decides to remain and participate, then that's it. You can't vote them off or
Okay.
ask them to leave, so it's,
But what if they don't feel they can make the rightful decision and they say they wanna just go sit in the back of the room? And we feel it would be best that they actually left the whole room. How would you go about doing that kindly to kinda get that across? So at least that, we've tried to address it on here, so let's say if it ever does come back, hey, look, I tried to get him to leave, he wanted to stay in the back of the room. Because we had had that happen,
Oh, yeah.
actually.
yeah.
And, it got to a point where, I don't know, he stayed through the whole meeting.
I
And
mean, sometimes it's like a high school auditorium and the person's in the back and it's like, well, that's not, but this room's not so big that if they're sitting, in the back, that could be a problem. So what, again, as a chair, you could say we've been advised by council that, once you recuse yourself, you leave the room. And then, but if they say, nope, I'm gonna sit right here, then
Okay,
they get to stay.
at least you have it on the record that,
Precisely.
Okay.
It just shows the rest of the board is being neutral, because that's why, that we ask that the person leave the room, because when a judge might look at it, say, well, that board member could be rolling their eyes or somehow exerting
Right.
some influence. So
Right,
if
influence,
you as a
exactly.
board make it clear, no, we want you to leave, and they stay, it just shows the court that, no, you guys are impartial and you were trying to do the right thing.
would it make sense to hold a vote, or was that too much?
I don't think I'd do a vote. You wanna make it that formal, but if you wanted to go around and just get like a roll call, if you will, just to,
Of opinion of what they
yeah,
feel?
as a chair, you speak, and then you could say, does anyone else wanna speak on
Okay.
this? Yes,
We do get in advance what's going to happen at
Mhm.
these meetings, the applications. Now, you would think that the person who views this, that's a full member on the board, or even an alternate, would say, by the way, I need to recuse myself, even before we even get into it,
Mhm.
okay? So, maybe there's a way of putting something out there, in an email before we even get to the meeting, saying if anybody has a conflict of interest with this, application, please let us know.
reminder. It's
Well, I
hard.
think-
You need to recuse yourself. I mean, I'm just saying, before we even get to that point,
Mhm.
you know?
The ones I found that are tricky, it's like, I do some work in Litchfield, and they have a Litchfield Historic Trust, which they're involved with a lot of properties in the center of town. And a lot of people belong to that who also serve on all the boards and commissions, so you get a lot of challenges, but if you're just a member of an organization, that might have a problem. I guess a classic would be the application is next door to say where you go to church, you're a member of that church, and they say, well, I think you should recuse yourself, because my application for a tattoo parlor, you church guys don't want my tattoo parlor. And you could say, I'm just a member. Now, if you are, some governing body of the church or something, that might be different. But so that's where these recusals, sometimes it's more those gray areas, so you might get caught off guard. You're right to, when you look at an agenda item, just to see if you recognize any name, if you own property nearby, that sort of thing. But it's those other ones that catch you sometimes. We just belong to a group, you had no idea that you're somehow could be seen as being opposed to something or in favor of something. The other thing with recusals is political statements. Are you guys elected? Or
Yes,
appointed?
you're
You're
elected.
That can't be held against you. Again, if you run for office and you say, I want to sit on the zoning board because I like Southbury the way it is. I don't want to see any more big apartment buildings. I don't want to see any more of this or that. And now you're sitting here and someone comes in and says, I want a variance because I want to change this single-family home into, a business or something. You do not need to recuse yourself because you have what could be seen as more of a anti-business or something. You're allowed to have opinions, general opinions. On
Oh,
how,
really?
Yep. on
So
how
if
want
you
to
were
tell
in
the law.
public at the diner and you spoke out like that,
Yeah.
somebody's coming in, they can't hold that against you in here.
I forget what town it was exactly. It was, and they were trying to rezone part of the town to allow development. And some guy, he runs to be on the planning and zoning commission. Goes, I'm against that. And then he gets elected to the commission, and when they vote on the amendment, he votes against it. So of course, it was, well, you were biased. You shouldn't have voted against it. You ran specifically to defeat that zoning amendment. And the court, when it went to court, you know, the judge is like, well, no, it's political office, he's running for,
But would that be based on hardship?
oh, I'm sorry, but I'm just saying with politics, you can be pretty specifically against certain things when you're running for office, and then when you come to sit here, it doesn't disqualify you.
Right, so that would lead it to be that, just like anybody else, if you feel you want the change, then you get on the board and you can vote for the change.
It's gotta be general, so, again, like you said, you're at the diner, and you're making a statement about a particular application,
And
and
that's,
we'll get to, yeah,
that's
don't
different.
never, if something's on your agenda, you just don't speak, it's like a jury, you don't speak outside this
Right.
room on it. So that's specific, but in general, you have a general, like, you know, how you would like Southbury to look, and, you know, you could run for ZBA saying, the zoning regulations are so bad, I would approve any variance, cause I think that, you know, whatever, but then, that's a general statement, and then when you come here, you know, you're not gonna be disqualified from ever voting on a variance application.
That's interesting.
Then I will restate again, if it's on your agenda, if it's an application, you know, outside this room, you don't speak of it until once you vote on it, then you can talk about it. If someone asked you, why did you approve that variance? Well, you can tell them once it's done. Here's why. I saw the hardship.
Well, I would hope you'd be able to talk about it.
Yeah, but that's the problem, is sometimes, you know, you have the hearing, you close the hearing, and you're walking in the parking lot, and someone grabs you, or a few people grab you, and you start talking about what you just did in here, and you really shouldn't do that, of course.
Right.
Because you still have to vote on it, yeah, it's not over.
Gotcha.
But they catch you off guard, and I don't know if you guys do it, but a lot of boards, commissions, sometimes you go out, you meet somewhere after, and, you know, have a drink or have something to eat after, you know, and people catch you there.
You shouldn't be talking about it.
No,
But it's hard, because it's on your mind, and you just did it, and they can get you going, so you have to be careful. And then, on page 3, just the right to enter private property you do not have, so you have to be invited.
So,
Normally, you could see from the road or from, you know, so.
so if somebody comes in with an application,
Mhm.
on that meeting, that public hearing, you should ask that applicant for permission to, you know, because you're gonna have a review process of it, if you
Right.
say, or it gets continued, to enter onto your property, so it's on the record that they in turn okayed you to
Okay,
come
there,
on.
sometimes in the application form, you can put a little signature line there too, as they fill it out, you can say, oh, sign here, so, you know,
That
just for the
allows-
purposes of that application.
Would that make sense then, to have a separate form for them to sign perhaps, maybe?
Yeah, just another reminder, like you said, you catch them somehow, you catch them when they're applying, or like you said, when you open up the hearing kind of thing. like,
Okay,
"Hey, let us on."
by chance, I'm sorry, I had to drop is there something, a pen, and, I can even write on the map? Oh, thank you. I just wanna have,
One of our fancy pens. You want one?
yeah, thank you, yeah.
Here.
Uh,
Bring it, Tom. Yes.
Steve, another thing is, when you're allowed to view the property, you're not supposed to be talking to the person that owns the property in reference to it. Now, I've heard former members, they're not here now, that did that, and I knew for a fact we weren't supposed to be doing that. So,
Right.
say Kathy and I decide we're gonna go view the property, okay? And we have permission. We do not engage in a conversation with the owners at all, anybody at all. We just go and view it and make our own judgments for ourselves.
Because you gotta
Yeah.
look at this from how would a neighbor look at it, where, you know, the applicant comes out and you're talking and you're laughing and having a good
Yeah,
time, and the
yeah.
neighbor who might be against it says, well, they're all friends with this guy.
Right.
He's gonna
right,
come in and say, you gotta recuse yourselves, you're too friendly with that guy. So-
Right,
So you're right, unless, sometimes just for directions, if you're not quite sure where the addition's going, you know, you can ask a couple of pointers, you know, where's it gonna go, where's the porch going, or where's the, you know, the setback line, and
Nor can they conversate about it either, correct, with each other?
at the site visit, if it's not a quorum, but we are always any kind of discussion should be at a minimum at a site visit, because it's not a meeting, you don't want it to somehow become some kind of a meeting. You know, all discussion should take place only at meetings and hearings, so.
Right, so if those two went out and they're
Yeah.
saying, hey, you know, if they move this pin over 2 feet, they can move there's none of that.
None of
as
that,
far as-
very just, if you just need directions, like, where do you think the property line is, where do you think, you know, so, yeah, minimal discussion, cause it's not a meeting, so you shouldn't really be discussing anything.
Okay, see, we need to know all that.
Less is more.
Yeah.
Let's see. All right, we can move on. On page 5, there's some conflict of interest examples. We kind of covered some of those things.
Actually, can I just ask one quick question?
Yes.
When they do have a site visit, if there is 4 people that are going out to it, then it needs to be publicized in the paper that this is transpiring and that the members are gonna be going to that property or no?
Not alternates, it's like if a quorum of regular members, I guess unless you
Correct.
seated an alternate, but right, so if it's a quorum of regular members, then it becomes a meeting, so it's a special meeting, you'd have to notice it, and then the public could tag along. And that's sometimes where the property owner is not too happy about having a lot of,
Correct, but if that was to transpire where 4 of us decided, 4 members, we're all gonna go out at once, then it needs to be posted in an
Yep.
adequate amount of time.
I
exactly.
think we've tried to prevent that from
Happening, yeah.
happening.
If y'all show up together, just a couple of you just, you know, leave and then.
Yeah.
I just wanted to be clear, cause I thought that
Yeah.
was the case, I just wasn't sure, okay. Right, so we wanna try to eliminate that from ever
It's,
happening.
yeah, it's best
It's
if
the
you,
best,
if you
yep.
do.
Thank you.
Yep. Okay, so we got conflict of interest, and then I think on page 8, I just put some Freedom of Information Act stuff, which I need to update with the new, you guys don't do remote hearings, do you, or hybrid meetings or hearings? Okay.
We haven't been.
I have
A
one commission
hybrid
at the
meeting?
where you can still have the video screen, you can have someone be remote, and it's a whole other set of requirements, to the point where you have to have equipment available in case someone, a member of the public, wants to watch it via video for whatever reason, they can go, and you have to have them all set up with
Is it mandatory that that has to be done?
new
Okay.
optional
I
stuff.
think we discussed that last
We
time.
did.
Okay,
We discussed it in our chairman meeting.
yeah, okay, yeah, all right, so that's, okay, we know where we're at with that.
Good. I have one commission that's still doing it. It interrupts the real meeting, cause
Yeah.
the technology, you know, drops out. And all of a sudden, it's all frozen faces up there. It's like, I think we lost the connection. Well, they spent the money getting all this stuff. I think they want to keep using it. But, okay. So there's FOI stuff. Now we can get to the real stuff, right? Some of you have the yellow cover, but
I think we all do now.
do you all have that? It's the better one. It's
John
the
does-
card stock.
Oh, you got,
I brought my own copy too.
You don't have the yellow cover though.
That's okay.
He's got the emailed edition.
Oh, okay.
Yeah, I got the email edition, yeah.
Oh, okay, I get it.
So I just start out with your powers and duties. The only thing with powers and duties, your role as a board, your powers can't be added to or taken away. It's what the general statutes, what the state legislature has provided you, cannot be taken away from like a local town ordinance or some regulation that tries to limit you somehow or give you extra authority, so. Cause some towns have adopted zoning regulations trying to restrict when you can grant a variance. And sometimes they'll even follow court decisions, and then that regulation gets appealed to court, and the judges just strike it out, say, no, it's what's in Connecticut General Statute 8-6, that's all you have.
so if your town elects to try and create other variances that restrict, say,
Mm-hmm.
it doesn't matter, it's what the state has.
Right, the state created you, so.
Okay.
Yeah.
That's very interesting.
Even when, like I said, a lot of these zoning regulations are well-intentioned, they've just taken a case decision, what some other judge wrote, and they just copy and paste it. And then some other judge says, well, where was that? It's not an 8-6 anywhere. It's gotta go.
And where are you looking at in the Genu statutes? So if I just Googled,
It's in the back of here. I'm not sure, let's see. Oop.
8-3C,
Huh, did a bad page cut off. It's really, it's on page 31, but it's really page
Yep.
32. Somehow that got it bad.
yeah,
Cut off.
well, it goes to the next page, A. Okay.
Yeah.
All right, so I wanna read that.
So to hear and decide appeals, where there's an error, so that's when you get an appeal of a cease and desist order. And then to hear and decide all matters, including special exceptions, which you guys actually do, right? Which is not so common. And then number 3 is the one you spend a lot of time on is variances, to determine and vary the application of zoning bylaws, ordinances, or regulations. See, in harmony with their general purpose of the regulations and intent. And you give due consideration for conserving the public health, safety, convenience, welfare, and property values. So it's half of that is really you're looking at stuff other than a hardship.
But if there's no hardship,
Yeah, there's no but if there is a hardship, but granting that variance would harm, would be detrimental to public health, to public safety, would hurt
Right, I
abutting
get that.
property values, yeah.
but none of that will fall into compliance if there's no hardship.
But you still do both. in
No,
case
I
it goes to
understand
court.
that, but I understand we're gonna do that due to the fact of what's gonna be best for, the town to not get, into a litigation of some sort.
Right.
But other than that, if it boils down to when they go through all this and we look, okay, yeah, this works, and this works, but you haven't proved hardship,
And if you grant an appeal, and any board grants an appeal, if it goes to court and you lose, the judge goes right to hardship.
right?
I don't see the hardship. It's gone. I have no case decisions on what
Anything else after
property value
It
or,
doesn't matter. It comes to be mute after
but
that.
you still gotta hit both, cause what if?
But you have to entertain it, is what
Yes.
you have to do. I
But if the
understand.
judge did find hardship and he's like,
Okay.
but these guys never address this other stuff.
Yeah, all right, I understand.
And you don't want it coming back to you, and the judge doesn't have to send it back. The judge could say, make that decision on his own, say, okay, there was hardship, and I'll make the other decision for these guys. And you never get it back.
So then at least if you do both, he's gotta look and address both
Right.
situations.
And put your concerns, because sometimes it is where, when you approve a variance, you can attach conditions which can protect the neighbor, can protect, or protect the public welfare and all that stuff, so.
So that would lead to the reason then, whenever your decision is made, you give your decision and then you give your reason for your decision.
Right.
Cause your decision then for your reasoning will be based on 1, 2, and 3, but out of 3, most of the safety, convenience, the
Right,
welfare
what's
and
the-
everything else.
Yep,
Okay.
what did you guys find important?
Because there was a while there that we were just making a decision with no answer. We're just raising our hand either yay or nay. And I forgot who it was that came up with that, like, no, you need to state on the record the reason why.
Yeah, it's good to go. I mean, technically, the judge says they'll search the record for the reasons, but, you're trusting someone's gonna,
Right.
our state judges don't have clerks. They're not like the federal judges have, young attorneys working for them, so, better if you guys do the legwork and,
Okay.
Okay.
but the applicants always will, at least what I found, they always first attack you with, it's a beautiful project, neighbors love it, it's gonna fit in beautifully, do all this landscaping for them, it's gonna be wonderful, more taxes for the town, all this great stuff.
Oh, it's, yeah.
And then what about the hardship? And they're, there is none. I just want to get this done. So, and that makes sense. They're going to sway you, and you're going to want to approve it. It's a wonderful thing. And then maybe you work together and try to think of a hardship. But as it was a recent court, not so recent anymore. Which one was it? It's from 2016. It's 5 years already. And this was when our state Supreme Court said that before you can find a valid hardship, the property has to have no reasonable use.
No reasonable use?
Yep, so if it's,
Go back, say this again?
if the property has a reasonable use as it is, there's no hardship. So if you can use it for something, not what the person wants to use it for, but can use it for something. So that's really your question when they come up to, what are you doing with it now? And a lot of times there's an existing building and maybe it's used as a single-family home, but everything that's around it is maybe, commercial, or it's two-family or something. If they could only make the building a little bigger, they could make it a two-family also, and, the town comes in, oh, we need more affordable housing, this is great, but it's like, but you've already got a use for it, it's already a single-family home.
But that's no longer, because as of 2016, they kind of took the restrictions off, is what you're saying?
No, they reimposed the restrictions. We were all going the other way, where if it was a
Being more
better
liberal.
use, yeah, even though there was a reasonable use, it was sort of, a lot of courts would look at it where it's like, well, like in my example, if all the other properties are two-family homes now, the judge would say, well, having that one last piece as a single-family home is kind of a hardship. You should let that guy have what everyone else has. In the case, which is,
Why would that restriction be there in the first place?
E&F Associates versus Zoning Board of Appeals. That restriction, well, that's what the court will say is what the applicant really should do is go to the zoning commission, say, could you amend your regulations so then, I could have what everyone else has.
Yeah, but wouldn't that open the door for everybody else throughout the whole town too, though?
Oh, no, I mean, well, that's, zoning would have to, right, they could figure out ways to do a proper zoning
Just in
regulation.
that area?
You might see that actually, where sometimes I always wonder if staff, if you see for the same part of town, the same kind of variance, usually it's some kind of a setback variance, where it's, when that part of town was zoned, there are already all these pre-existing lots that were built on, but then the zoning commission, for whatever reason, increased the front yard setback or the side yard setback. So now all these people, they can't put a little stoop on their house, they can't put a little garage on their house.
That's
'cause all of a
most of what
sudden-
we get,
Yeah, and
Yeah.
if they're all in the same neighborhood,
yeah.
and that's what the court says, well, maybe, it's not right to give them all variances, they should probably go to planning and zoning and say, hey, could you rezone our neighborhood? We all wanna have a two-car garage, but because your setback requirements are this high, we can't get it, we want, so. Cause remember, with the hardships, it'll be unusual too, so if it's person after person on that road, and the real giveaway is, you guys approved my neighbor's variance. That's telling you, well, that's not unusual, then you and your neighbor have the same problem, that's not an unusual hardship, that's a shared hardship. You really should be going to the zoning commission to get the rules changed.
And how would you go about doing that? I mean, would that be something that you have to preside to the public to make that decision, or is it something that can be done within an internal?
Well, it could be the applicant, you could, just give them some, I shouldn't say advice, but when you turn them down, you might say you might wanna go see the zoning commission perhaps, but
Right, but how would the zoning commission change that regulation?
they can amend their own regulations.
But what's the procedure? Is that something done in-house, or does it have to be publicly done?
Oh, no, it could be in-house where, discussions among yourself, like, you yourself as a chair talks to staff, so we're getting a lot of these, we have to keep turning them down, maybe the zoning commission should look at
Oh,
this.
so it's not like a major process to do? It's
No.
not like,
It's a major
Well-
process for the zoning commission to do, but not for you to just.
Correct.
send a
Correct.
memo or a suggestion to them.
right, but the zoning commission, I mean, what do they gotta do? Does that?
That's a zoning amendment, that is a formal process for them,
Right, but that's a pretty big ordeal, I mean, I would think.
that's why,
Yes, and
yes and no, yes and no.
I've seen it a lot with the PDDs, they amend their regulations, a text amendment is pretty similar
Yes, it is, yeah.
process.
There's a public hearing and
But for
there's.
to amend-
Right, so you do have to have a public
Yeah,
hearing
oh,
on it.
yeah, yeah.
So it can get shot down, so let's say the rest of the people come in there in that neighborhood, and they say,
Well, it's
well,
also referred to planning too.
True, yeah.
So, I mean, there's a
Separate.
lot of opportunities for it to not be,
come into.
That's why they come to you first, cause they
Right.
hopefully get a variance, but it's hard, cause it's, for you to grant a variance, that hardship is supposed to be unique, it's supposed to be unusual.
Right,
And if it's a bunch of people from that, you find, we just approved the variance last week for the guy up the road, and there's another guy, and there's another, now they're not unusual anymore.
but then don't you have to grant that person that's in there because you did it for him, and him?
No, you are
No.
not
Oh,
bound.
really?
no, then it's not unusual,
It's not precedent.
right?
If you have a decision that goes to court, if, you approve, it, and the judge says, Southbury ZBA, don't you ever do that again, that's precedent for you, if a judge somehow, But your own decisions, if you find out, wow, we shouldn't have done that, you do not have to follow if you think you made a mistake.
So am I mistaken then, if me and my neighbor have an identical situation.
Mhm.
Houses were built the same time, the road, the frontage, and this
Yep.
and that. And in 2015, he came in to the zoning and said he wants to put a front porch on, and they said nope, and then he comes to the ZBA,
Mhm.
and they in turn, he shows he's got a hardship, and they grant it to him. 5 years later, I come in, no rules, no regulations have changed,
Mhm.
and I say, well, hey, you know what, you gave it to him, don't I have that entitlement?
It's not unusual. Now it's kind of becoming a common thing, isn't it? It's not unique.
Right, but I thought under the law that if somebody else, the way that's what I'm saying is, I
But
thought.
what if the board changes? You know what I'm saying? Like, say, what if, you're saying 5 years down the road, someone else comes through, what if there's different members sitting here?
No, but you're looking at the fact, not, doesn't matter who's voting on it. I'm just saying in general, one person was granted it, I would think that, then, no different than if you were able to stipulate, if I'm not mistaken as well, if, you created a crime and identical to somebody else and they got off, you have entitlement to get off because it was identical, I mean, without any phase of being slightly different. He got off, then I should be able to get off too.
But the unique thing with your board and with proving a variance is, again, it has to be unique. So sort of by making your argument, you're sort of showing it's not unique, it's actually a common issue.
And then that makes it be able to be struck down?
I know, yeah.
I'm glad that conversation came up because I was automatically under the assumption.
No, because right, it's in a way, if you go to court, why you say about precedent is sometimes it's good to show a judge, you're being consistent, you're not being arbitrary. So that does, if you're consistently giving. But the problem is with variances is by their very nature, their definition, they're supposed to be unique and unusual. So if you have a pattern of the same, now it's different, it's town-wide, if it's over here and over there's a few examples in town, that's unique. What I'm saying is where it's kind of the same neighborhood.
All right, so theoretically then, if, let's say, because I really need to be clear on this because I was under totally different thought process. That person in 2016 gets it done.
Mhm.
The next person, it's now 2021, they come before us. Now, we know nothing about 2016. And he turns around and says to us, well, you granted it to the guy down the street. Should we then say, okay, we need time to research this and then give him the pass on it and approve it? Or should we still say no?
At that point, I know you almost pointed out that it's not, it's a similar problem that other people on the street have, a similar hardship, I should say, so,
Right, but if we shoot it down,
I know.
I mean, do we have the entitlement to do that and shoot?
I would review the application and hopefully find if it was
Similar,
Yeah.
and then you would then by default give it to them as far as
We
approving it?
don't really have, I mean, there are neighborhoods where there are a lot of applications for variances, but for different reasons, not because the town rezoned and changed the setbacks. We have like the Berkshires where there's legally non-conforming properties, just undersized lots and things like that, but there's nowhere that I can think of in my time here where it's, okay, this one neighborhood is known because they changed the setback. The only time I ever saw that was that one application that you and I dealt with,
Right, and that was,
but I've never seen anything like that since. That was that one example, but I haven't, and that guy, he had the smallest lot on that road. So, his was unique, but I don't think he ended up getting a variance anyways.
but what I'm asking though is that if they're identical, let's just say, just for hypothetical sakes, that they are identical, and that person, and let's say it is found to be that we did grant it in 2016, what would be the process? Would it be, helpful for our town to say, okay, we're gonna approve it because we approved it down the street? Or is it no? I mean, no, it's still,
It's on its own merit, so
Right.
every application is reviewed on its own individual merit. not
okay,
based
so there's
on
no comparison.
precedents or anything, and what I think Attorney Byrne is saying is that if you find a pattern, like when I worked in Roxbury, all those old-time barns used to be right against the road, and they
Mhm.
were being told either they're gonna be torn down or we're gonna wanna use them for like so.
Repurpose
So
or whatever.
we went back to the zoning commission, and the zoning commission wanted to save these barns and rewrote the regulations to allow these to exist within the setback
Mhm.
and let people build onto them and make them useful.
Mm.
But in your case, I think every application is its own thing, you review it by itself. Don't think about what happened in 2016 or, you know,
Good.
what's what's happening at the neighbor's house. You have to just think about it
Okay,
that way.
no, that's good to know.
Am I correct?
Yeah,
I don't
yeah.
wanna over.
No, no, you're right.
No,
it's
that's,
done.
I understood it the way she pointed it,
So, I
actually.
have a question about reasonable use.
Mhm.
There's a lot of non-conforming lots, or not lots, somehow parcels in Southbury
Right.
that there's no use for. But when you said that, I wanted to understand, so should they be allowed to come to the ZBA?
On the one hand, they have to be allowed, right, a reasonable use, because otherwise it's a confiscation. So someone would have to pay them for that lot, which does lead you to make the inquiry, what did they pay for that lot? Because what they paid for it equates to what their reasonable use, what their reasonable expectation to use it for. So if they paid $1 for it, like they knew it was kind of
So it's
worthless.
based on value in a sense.
Yeah, but if they paid full price for it, way back when, and then, maybe someone's grandparent paid full price, and then over the years, through zoning, it's the point where if you applied all the setbacks, there's no place left to build on it. They would still get to make a reasonable use of it, which depends on the zone, would dictate, what permitted uses are in that zone. That's a reasonable use.
Interesting, so, Zvas, you just missed the conversation on reasonable use on a non-conforming, pre-existing non-conforming lot. Right.
It's basically what's permitted by the zoning regulations. However, you are allowed to ask what they paid for it. And if they paid $1 for it, well then a vacant, and it's reasonable use to that guy is, it's worth $1 as a vacant lot.
That wouldn't be on record, what they paid for
That would be,
it?
it should be on record, yeah,
Yeah.
what they paid for, what they're getting taxed on it for, so. So if they paid, if it's worth X as a vacant, as a hayfield, or as just and there was one case where it was an old subdivision, one of the lots, a small lot, was actually used for a community well, which had been, but then city water was brought in, so the well was shut down. And some guy he sold it, and then the guy was trying to build a house on it, but he didn't pay anything for it. It was just an undersized lot, there was a well on it. So the reasonable use was then what he bought it as, which was just a little vacant piece of land, so. You do get to ask that question, because you do get these speculators who come in and,
All the time.
yeah,
There's
yeah,
a lot of them in
yeah.
Southbury.
So where would it be to draw a line to where that if you pay, let's say, it's non-conforming due to the size of it, where would it be to where you'd say, okay, you can't put a house on it? You'd have to pay what market value is, or?
Well, if they paid,
Is that a ZBA decision then? So, because it's a non-conforming lot?
or non-conform, yeah, maybe what they wanna build, they need, some variances for setbacks. You're getting a lot of these cases with shoreline communities, cause a lot of houses got knocked down because of, the various storms we've been having, so they wanna rebuild. But because some of the storm got, some of their lot got washed away or whatever, they have to relocate their building site into like the front yard, rear yard, side yard, and the courts have routinely said, they do get to have, in that case, a single-family house. They may not get the house they want, but they get a reasonable use, which kind of opens the door to you guys to use your discretion, what's a reasonable use. It's not gonna be on those shorefront lots where there was a little cottage, they can't all of a sudden put up,
A 4,000
a McMansion,
So
exactly.
their hardship would be
But you
that
can't
they're
hold
not
them to a
getting
little
the
cabin
reasonable
either,
use
so.
of their property for what they paid for.
Yeah, so
That
it's
would be their
really,
hardship, and then it would be up to the ZBA.
so it's a lot of, you guys could do a lot of, what's fair in that situation, and what did they pay for the lot, what did they have before, that kind of thing. But in the case of a vacant property, you kinda have to ask what the guy paid for it. If it's a vacant, he might have bought it for $1, and well, you know what?
And they can't come after you for being discriminatory in any way for that?
No, cause it's, again, it's somewhat, as Ty said, your work, it's so, you're on a application by application, little piece of property by piece of property. Zoning, planning, that's the big picture. Your purpose is, you look at things, that little, you expand your view maybe to incorporate what the neighborhood looks like, what the neighbors, how they might be impacted, but your view is so much more, precise, that kind of.
How would you determine, let's say there was a 1,500 square foot house on it that got knocked down, they lost part of the shoreline to it, they had to move it back, and where would you be able to determine what size square footage that you'd be able to put? How would you calculate that? It would be,
What I've seen done is you look at what was there, so they kind of should, if
And
they
do a
could,
value
get back with
assessment.
at least what they had, and that tends to work in Connecticut, 'cause a lot of times the older houses are more reasonable in size, and, but then you can also look and see what other people have, but what the court has said, they kind of get back what you had, is what I'm trying to say, so if, in these cases.
by value or square footage? By
Square
size?
footage, by square, so
Okay.
they allow you to get the high-end kitchen, the high-end bath and all that stuff, so.
Okay.
Yeah, the way you look at it, you're looking more at what's the footprint and the envelope or whatever the,
Okay.
size. But vacant parcels just can be tricky, cause sometimes you have people, it sounds kinda harsh where you tell someone, they got a super deal on this piece of land where they paid next to nothing for it. Now they wanna put a house on it.
But we had that just recently where they bought this property, relatively close to this building here, and they wanted to do something with it. And it was like, you look at over the history of that property, they've got so many as exceptions given to it to go from a house to a commercial, expanded the parking lot, everything to the point where the parking lot actually almost went right up to the property lines.
It was on the property line.
Yeah,
There was
and
like 3 variances.
so now they have enough parking to actually make the structure bigger, but being the structure would now increase in the size of the footprint, would now make it less conforming, and, naturally it got denied, but it was just like, where do you,
Yeah.
that's another situation. I'm sure she got it for a good price, but where does it fall that that person should have done the research before they purchased it? You know what I'm saying? So she's coming to us, or, excuse me, they are coming to us with this hardship of not being able to do it, but it's like, well, you bought the property, do we have the right to say, well, you really should have done your homework before you
Kinda
bought
went
it?
right into self-created hardship, didn't we?
Right, so I mean, do we have the right to say that, or no? I mean, would we,
You have to be careful with self-created hardship, because, with land use, it's always, we're not really looking so much at the user, it's the use of the land, so with self-created hardship, where is it? If I can find, got it in the book when I came across, I'll never find it now.
Yeah, but with that, because of all the changes, the town kind of made the property useless with all the changes over the years.
no, actually, the town made it more useful because what it was originally for as a farmhouse now became a business on the first floor and had a one-bedroom apartment or whatever
Yeah,
apartment above.
apartment,
So it actually got better, but they wanted to make it grander than that.
Well, yeah, that would, they
So-
wanted to expand, yeah.
Yeah, so they were trying to sell us on the fact that the square footage wasn't increasing, but when you
Maybe.
looked at the footprint, it was like, I don't know about you, but I did the math, and you were 219 square feet
It's not as good as I thought.
larger than what you're stating, I mean, there was so many things on it. But
Here's-
my thing on that is that before this person had bought it, they should have done the research if they can make it larger.
She still had reasonable use of the property.
Correct.
She could have used it
As is,
in the
Right.
condition it was that she purchased it.
right.
That they-
Because you don't guarantee the highest and best return for people, so a lot of times they're just unhappy with what they have, they want more. And you have to say, well, what you have is kinda, it's a reasonable, and again, you guys do have, which is kinda makes your job interesting but difficult, there's so much on a case by case, and you're making these judgment calls where, what is a reasonable use? And that's when you look at, what they pay for, what's, and then what, and does what they're using it for, get them kind of reasonable return for what they paid. They paid $1 and now it's worth $2, well, it's like, doubled your money on that, didn't you? So, in this case with a shopping center or something where there's a smaller building, a new guy buys, well, I wanna expand, I can get another tenant if I can add on to that. You know, it's like,
Well,
well,
my-
what you got is what you paid for.
My question is though, are we able to state that to the applicant? We understand your situation, but before you bought this property, you should have researched its maximum potential. And now that you want to exceed what it's already granted to, that can't fall on us. Are we able to make any type of verbiage of that, or should we stay away from saying that?
Here's the deal with self-created hardship. It says, where the hardship is created by, the adoption of a zoning regulation, and the owner of that parcel could have applied for a variance and doesn't. If he then sells to someone else, that's future owner could apply for that same variance. So what you need to do, when they come in and say, I need this regulation, I need a variance from this particular regulation, you first ask them, well, when did you buy the property? And then when was that regulation adopted? So if they own the property or who they bought it from, that's why it's tricky, but they have to have been an owner or bought it from someone that predates that zoning regulation.
Correct. But so we should stay away from saying, hey,
Right.
you should have researched this before you bought the property, that's self-inflicted.
And often you will find that where it's like they come in and they say, well, I need a variance from a side yard setback. Why? Well, I sold some of the property off to my neighbor 2 years ago. Well, that's kind of self-created, isn't it? They reduced their lot size. So, and the classic is too where they added on to the building and they get caught, right? And now they're in the side yard, and those are the easy calls. The tougher ones are when it's usually an unbuilt lot where it's just a vacant lot's been bought and sold over the years, and the regulations change. But the right to build on that lot to apply for variances, that jumps back to that original owner, if you will, because the lot's unchanged is what I'm saying. No one's built on it, it's not changed in size.
So then they do have the right to go all the way back to the
They
original?
can, yeah, to do but that's a lot of work for them you don't do the work, they have to bring the evidence to you, so you can ask the questions, but say, here's what we need to see. That lot, how do we know that it's in its present configuration, it's always been that way, since
I mean,
before
that
that
would be an
regulation
easy case to
adopted.
prove though.
Should be.
So, just so I'm clear, if the setbacks change on that lot from
Mhm.
1970, nobody's ever built on it.
Right.
Through these regulations, the setbacks on the frontage kept getting bigger and bigger and bigger and bigger, and now made it to where theoretically you could only put a 200 square foot house on it.
Yep.
They can actually go all the way back to the origination of the original adoption of this town's setbacks on that lot?
Yeah, because that original owner was still alive, and he or she came in, you'd be like, we wouldn't have an issue with that, but
Wow, that's
we
interesting.
seem to get confused when it's like their great-great-grandson, or they sold to this guy, and sold to that guy, and sold to that guy. My father-in-law has a couple of lots in Bloomfield, he sat on those things for 50 years, and
But it's interesting, because I thought as the time goes, if nothing's done, it doesn't matter. I understand it's.
well, they got a variance, yeah, they can, and you go back, and that could be their hardship, so where their hardship, they didn't do anything, the town just adopted regulations, which reduced their buildable area, but in your example, it reduced their buildable area.
So would that be considered a grandfathered clause in, that it goes to the
In
original?
a sense, it's not conforming, so they're coming in, and if you don't give them the variances, well, now he can't build on that lot, so there's his hardship, where you've confiscated it.
Wow, you just opened my eyes to a whole new.
So that's the one that I always found where people, it's when it's a vacant lot and it goes, and it's just, it's like, when you bought that, you knew you couldn't build on it. But if they can trace it back to, no, the guy I bought it from, he could have applied for a variance. He owned it way, in 1940 or something. Predates zoning.
Gotcha.
So they could have, had that lot changed since the original?
That's
No,
what you
because
asked.
there is a use to it. There's a use to it. What he's saying is if he has the lot and there is no use because of the setbacks gotten larger.
Right, gobble it up.
Now it becomes a non-usable lot, but if you can go back, they have a use for it. They already have.
But you're right to ask, as that lot changes, have they sold off pieces of it or anything like that? So it
And if
needs to
it
be
hasn't.
that same, so they come to you with the map.
Yeah, the same footprint from when the
Yeah.
zoning changed at that time.
Right.
Wow, I didn't realize you could do that.
So that was like two times ago, that one guy.
No, it wasn't a vacant lot, I don't think. It would have to be vacant. If there's a structure or something already on it, then
Yeah, there
it's
was a
got used
structure
to
on it, but
Cause I didn't ask you, you guys have merger provisions in your,
In the zone, right?
yeah, I don't think so.
I don't think so.
Most don't, some, I don't think you're there yet, usually it's like Newington, West Hartford, really 100% suburbanized towns will have a merger provision in their regulations where non-conforming lots will, if you own two
Two
together,
side by side.
yeah, they merge. But
Um,
often not towns like this, usually it's really those heavy, the town or cities built up,
And there's no more space,
no more space, they're trying to get rid of those little
yeah.
remnants.
Is there, is it, going back to the initial application, okay? When a person comes in to make an application for ZBA, okay, they give it to the ladies and the ladies review it and they say, well, you need this and this, right? Isn't it on the form, you need this and this, or they ask you, when did you buy it? When,
They submit the application and then it's reviewed for
Right.
completeness. We don't tell them what to put
Right,
on
but
it,
it's-
but we make them understand what you'll
Provide
be
it.
looking
Right,
for
so-
at the meeting.
okay, so part of it is when they bought it.
I don't
And then
know.
that's an application question.
Yeah.
That would be something you might ask
Mhm.
them
Right.
if it pertains to.
When it was
what your
purchased, so,
decision
no,
is.
it doesn't,
It's
no?
not on the application.
We may put in the review if it was.
Yeah, like I'll
'Cause it might not
do a
always be relevant,
staff
right?
review and kind of give you some information on the file and the history. But no, it's not, I don't think it's an application question. It's more, that's
Hmm.
more, the application questions are more geared toward what their proposal is, not the history of the site. So it's, what are
The
you
use, not the
proposing?
user, as they say.
What regulation are you
Yes.
asking to vary, and what's your hardship? Those are the kind of things.
So what I'm talking about is, it comes up more when it's, like I said, when it's a self-inflicted hardship kind of thing, then you'll start to need to know, when did you buy it, and then when, was the applicable zoning regulation adopted, try and see if, their predicament, did they create it, or did they, or what, does it predate, the zoning regulation in question, so.
yeah, what I was talking about, I mean, strip everything else out of it, cause we had talked afterwards, and we said, oh, he wasn't the original owner when the zoning changed, so nothing applied to him, but now because what he just said, it does, because that property was never touched and he was the second owner after it changed.
Yeah, but that wasn't a vacant lot, that was.
No, that has nothing to do with it, I'm just saying, we were under that understanding, like, if a new guy comes in and buys a
Mhm.
lot that got changed, that fell into a different zoning and was changed to the previous owner, when the new guy picks it up, it doesn't apply to him, but it does. Cause if no one ever, if it was an empty lot at the time,
Okay,
we were going to the understanding, if this guy had bought that empty lot from the original owner who had it during the time of the change of the zoning, we said, well, he's the second guy to own it, so he can't apply for a variance and go back and grandfather, but he can.
he
That's what
can,
he's
but
saying. Now,
since there was a
so
structure
it's-
on it.
Yeah, it's just switching our whole,
Right, okay, alright, no, I
nothing to
understand.
do with structure, I'm just saying, and the
That
mentality
he
is.
could, right, exactly, that's why I was clarifying,
Yeah.
because I always thought that once the zoning reg and it changed hands, that became the new rule to it regardless. I didn't realize that there's exceptions in it, so
Yeah,
that's.
cause just like a variance, once you approve a variance and they record it in land records, that variance runs with the land, so if that guy sells that lot, the new owner has the right to that variance too.
Right,
So it's sort of like, well, the right to apply for a variance also kind of attached to that, vacant
Right,
piece of
we
land.
were thinking that he didn't
Yeah.
have a right for a variance, but he does.
That's why you can buy land, if you own a vacant lot in town, you're not so worried about, you can always sell that thing, you have to watch the zoning commission to see if they're gonna upzone your lot so it's worth nothing, once that's a legal lot, it is protected, so.
so that kinda supersedes the grandfather clause then too, basically,
No
from what
way.
you're saying. Because I'm in the same situation in Waterbury, as far as I have a vacant lot, it has a 50-foot frontage.
Yep.
There's no more 50-foot frontages in Waterbury. But I bought the 3 parcels, the rear and the side, and I have a
Right.
two-family here. And I went to the city and said, I wanna, build on it, and they were almost giving me a hard time. I said, whoa, wait a minute.
If it's a
This
legal
lot
lot, it's
has
a legal
not
lot.
changed.
Yeah.
This has been this way ever since that subdivision was formed. I still had to go through a process, but then it was approved.
Yeah, that's
Once I
correct.
proved and had it surveyed, put the expense in, and
Mhm.
showed that the lot conformity has not changed, they made it, and it's automatically approved
Yeah.
as a building lot.
Right, so those rights
Right.
attached to that land.
But I thought it was just due to the fact that it was grandfathered. I didn't realize from what you're saying. And what you're saying, it just opened my eyes to, you know, cause I build homes and stuff, so I'm always looking for property. And I always
Your business
thought,
opportunity.
absolutely, you've just created a whole different
Well,
thought
no, there's-
process for me.
Yeah.
And that, you know, so that's why I said, wow, this is great, you know, because now I can start expanding my horizons on stuff.
Just not in Southbury.
Yeah. Well, there's not too much of that, I don't think. I mean, although, you know, Taya says there is, I'm gonna start looking
There are,
around.
but they're not, but Justice pointed out, she doesn't believe that Southbury has ever changed lot size requirements.
You need those old, like, towns, or it's like those old, like, where there was a mill, textile mill, and then you had like the workforce housing, like, from like
Yeah.
100 years ago. So it's all these little tiny lots and little, and those people can never add on to their,
Well, we have the whole, right over here, Lakeside, it's
Well, that's,
a lot of that in there.
Right, but those weren't
those weren't initially.
legal conforming lots.
To begin with.
yeah.
I got you, okay,
That's why a
right.
lot of those, like, they're old, like, vacation areas, if you will.
Right.
Exactly.
Yeah, that's often there's, yeah.
Don't buy them.
Don't buy them.
It's a bad investment.
Yes.
Yeah, cause everybody wants to go
Not
up,
for the purpose
and
of
overhead.
doing it.
Like you said,
Overhang.
Waterbury, you gotta find those little, you know, like Bantam, stuff like that. I mean, the lot of stuff going on in Bantam, and, cause those lots are, they're, you know, you can, they're, go to Bantam. No, it's too late for Bantam, it's already.
Yeah, it's awful. Now, the taxes are ridiculous.
A lot of New York money found its way in there like five
Oh,
years
man, I
ago.
feel sorry for all the senior
Oh,
population.
yeah, go up
that's
there,
in
it's something else, it's
It's changed.
nice
The
restaurants,
taxes
yeah.
just supersede a lot, I mean, a lot of the older people that live there, they can't even afford because of the taxes.
No, went a little too far.
Yeah.
Before
right.
they loved it.
I mean, people are losing their houses, you know, that they lived there for 50 years
Yeah.
because they can't afford to pay the
It was
taxes.
great for, you cross that line where it's helping, and then it gets to be where everything jacks
Yeah,
up.
that's so unfortunate.
Yeah, yeah.
But I think, I mean, I don't know where we're going on it, but I think as far as the elevation thing that we had
Oh,
talked about,
yep.
as far as that, I think that would be a great thing because, there's a couple of questions I have as far as extending over the footprint and stuff like
Yeah,
that, so.
expansion, always comes up, like a vertical expansion especially, but in general, the
Section 13?
footprint. The definition of an expansion of a non-conforming structure is something that constantly gets debated. So like if you're staying on the same footprint and you're going up, is that an expansion of a non-conforming structure?
Believe we've determined.
We have, but I just want, it would be nice just to talk
Yeah,
about it
sorry.
a little bit, yeah.
So,
I mean, as long
non-conforming
as it's under
structures,
the height regulation, I would think you'd be able to, but, you know, as long as if it had city water and city sewer to support it. But that's where you're saying no, so you know, that's why I'm kind of a little confused.
because
on-
with, you know, with a non-conforming use, it can be intensified, but expansion is, you're not supposed to allow it to expand, basically.
But what's expansion? Is expansion going vertically as well? Is that considered to be expansion, or is expansion just the footprint? Because when you look at something, you know, as a bird's eye, as far as expansion, you would think this parcel's getting
It's
larger.
definitely the footprint,
Right, it's not, so if you went
but
higher,
it can be
oh, it can.
expansion, it can
I
be.
think they leave it up to however the town writes its zoning regulations.
Right, so if, especially like the cases down by the shore, you know, where there's a view involved, that kind of thing, where people do worry about, I guess it's more like a bulk thing where,
You don't wanna block the people
yeah, but it
across
could be
the
someone's
street.
sunlight too, you have a case where your neighbor builds, maybe blocks your sunlight to your garden or something, so it does, but a lot of towns, regulations in the court lets it slide where they, if it's in your regulations where you allow, I think Morris allows like 25%, but that's more rural, so they allow people to,
It's not in ours, so.
no, I look, yours was pretty straightforward, just says nope, it just says,
So then, under the regulations, they can't expand square footage, period.
correct,
It doesn't matter if it's horizontally or vertically,
Right.
it's a no in
it's pretty
some
strict,
areas.
yeah.
And sometimes like it comes into debate, like, well, if we're expanding in the back and not into the front where you're into the setback, but it's still attached to the structure and you're still expanding the structure itself, and there's nothing in the current zoning and regulations for this town that allows.
But you could.
Any kind of,
Now, we could talk about too, you can do a little horse trading, where at least the courts have allowed where someone wants to put on a porch on the front of their house, but they already have a side yard, a porch on the side which is in the setback, so they say, how about if I remove the side porch and you let me have the front one? And the front one's gonna be a little smaller. I'm reducing the nonconformity.
So you can actually negotiate like that?
But only if it's reducing.
Yeah.
Conformity.
You guys can look into that when they come in, cause they can apply for, a variance can be used not just for like, to get rid of an unusual hardship. If they're gonna reduce a nonconformity, that's where they come in, I wanna have a garage, but how about if I get rid of my porch? And I do that instead or something. So overall, the building's more conforming
By square footage.
by square
wise.
footage.
And
Yeah.
also, I mean, and also you're taking it out of that non-conforming area. It's not just randomly selecting some
Mhm.
square footage. It's gotta be
Right.
the square footage that's in the
Non-conforming
bad,
square
in
footage
the
versus,
bad
yeah.
part, and you're adding it to the good part, and then.
Gotcha. Wow, I didn't think that would even
Shifted
be,
I know,
To
yeah.
be, now it's less non-conforming.
This
and
case is
that's
on, yeah, it's
what
where
the
it's,
goal is.
but
It is
that's
kinda-
only on, I mean, because all the ones on Lakeside, those are non-conforming, period.
Yeah,
So to
it's
do any
entire-
horse trading, you really can't do it on those.
Right,
nowhere to go.
yeah.
Yeah, there's no, I mean,
Right,
yeah.
and if they were to go up, they're still adding on to that area of the house so you're still enlarging your
You're expanding
non-conforming
your-
structure.
Expanding it, yeah.
Okay, that's good to know.
Are there a lot of issues with the houses down with like
Lakeside?
going up, yeah?
Well, we haven't had a ton of it, but, I mean, everybody wants to because they're a cottage, they're,
Well,
eight
Yeah.
hundred square feet, you
Right.
know?
Sure.
And they, they got 3 kids and they wanna go up and they thinking they can and they can't.
Mm.
Because the lot period is just not conforming, so no matter what you do, you're gonna be in violation.
Mhm.
See, I was under the interpretation that, hey, as long as you stay within your footprint
Sure.
and underneath the 34 feet of, or what is it, 38 feet in this town for height regulation? 40 feet? You could go, I would think, as long as your
Yeah,
septic
why
and your
wouldn't
well
you
can
be able-
support all that. I
You
figured
can't.
you'd be able to, but you're saying no?
No, not,
Yeah, for
can't.
years,
I-
that's what everybody was doing out there, is going, okay,
Go up, right?
go up,
Yeah.
yeah, but you can't then,
You
huh?
can't, well, that's what they're saying, yeah.
yeah.
So
But if it's a
40
corn-
feet would be the max height on a,
Anywhere in Southbury.
Anywhere.
Anywhere in
If
Southbury,
you're-
that's
if
good to
you're
know,
already-
thank you.
If you've got less
Yeah.
than 40 and you're already non-conforming, you
You
can't,
can't.
Correct.
Right.
you
Yeah.
can't go up.
Well, it's
Okay.
all based on your fire department and what they can reach, if you had a structure that's taller than that and they can't reach it, you're gonna burn to death. I mean, there has to be a limit somewhere as far as what you're able to support. I believe if that's true, I mean, it's, a lot of that's based on the fire marshal as far as your height.
Oh, very much so.
Yeah.
By those-
Yeah, I'm taking this all in, so
Yeah.
yeah, it's just good to know, thank you.
Yeah.
Thanks for
When people ask
answering
why
that
you
for
have
me.
those types of restrictions, why does a road have to be a certain width, why do we need a turnaround a certain diameter, all
Yeah.
those things, water pressure, why do we need to show water pressure?
Yeah.
That's in with the zoning, it's in there for, public health, safety, property values. so.
That leads, so I'm new on that too, is the definition and the reasons for setbacks. Is there somewhere I can go to?
Those were historical, and I've been looking more into it, because, we had that whole, to get political, but the whole desegregate Connecticut thing was zoning was done for one purpose, which was not a nice purpose, but, the reason for setbacks was to prevent the spread of fire, basically, and to allow for, fresh air to flow between the buildings, so.
Right.
And also in a pandemic, your neighbors' germs don't creep over into your place, get that nice open, so,
Yeah, but if that was true and somebody's got a 2-acre parcel subdivision, you'd have to have a real
We do
strong
abuse
germ to
those,
make
yeah.
that distance. So I don't know.
some of those setback side yards, yeah, kind of push,
Yes.
yeah.
Yeah, because there's properties.
It looks nice. You go up Litchfield on North Main, North Street and South. You got
Oh,
those
yeah.
nice lawns.
Oh,
and
yeah,
it's
but
beautiful.
the setbacks then should be really irrelevant.
No, it's more like when it's more suburban or urban, where you do see, why do you have 10 feet on each side, so it's a 20-foot, and that's to prevent the flame. I don't know what the fire department says, what you kind of want, and then a fire rating, and just to slow down a
Even
fire.
for like the properties that are set way back in the woods, cause we got, some of
Yeah.
them are at 30 feet.
Yeah, you brought that whole thing.
Yeah, when it gets to
Go ahead, preside it to. You know what? That'd be a good argument for him to answer.
Well, I'm just, what it comes down to is, for no other reason, but, okay, the way I look at regulations,
Mhm.
and what we should be doing here as the zoning board of appeals is, in the military, we had regulations, we need to have a variance to the regulation or amendment to regulation. Regulation says you can't have the setback, or you have to have a setback of 30 feet due to the reason the fire truck has to get through there.
Or something, right.
All right, now, I gotta build a structure that's gonna go into that, but the structure is not gonna go so far as to impede a 8-foot wide fire truck.
Right, and the fire marshal maybe get a letter from him.
Right, yeah, the fire
or her.
marshal, can I get a variance?
Mhm.
And then we would approve or disapprove it, my commanding officer would approve it.
Mhm.
That's why I'm asking what the setback is, because if they can, still, reach the requirements for the setback, why can't we say yes?
Right, so it's, say you find a hardship, right, you could reduce that side yard, that setback.
But you have to have a hardship.
But provided you wouldn't, and that's the second, there's a hardship, but then you can only grant so much of that variance request in order to, like in your case, provide for,
For what it
Fire
needs to be
protection,
done,
whatever,
yeah. Like,
exactly.
what is the purpose for the setback? Like I said, is it
Yep.
for sewage system? Is it for a fire truck to
that's
get
what it was
through?
historically, it was for fire protection, also just for, light and air, so fire is the big one, so the fire department said, no, we need this much space.
Right.
Or, if the fire can't jump, we need at least.
Yeah, and we got
Yeah.
properties that are out in the middle of the woods
Yeah.
with nothing around them. Why do I have to have a 30-foot,
First, before there, when it was all wells and septic, all the lots were half acre, at least in Farmington, so you had these pretty nice setbacks,
Yeah.
but.
Well, I think his argument is that he wants to put his garage there. That's where he wants to
So he's
put
gonna
it.
get close to his neighbor's house now, so how much space do you need to preserve?
But there's nobody
open?
there.
Yeah.
Yeah, but
So
there could be.
it's like, where's the harm? Where's the harm come in? And it's just the fact
But
that.
that's the other side, so if you find the hardship, and then you say, well, if we grant the variance, are we causing harm to anyone else? And you would say, well, in this case, maybe not, cause there's more than enough.
But there's no hardship. He's got plenty of room to put it anywhere
Right, well,
else.
it's,
So it's like,
it's all personal.
and that's where he's
Yeah.
like, well, I wanna put it, that's where I wanna have it. And I'm like, well, that's where
Well,
there's setbacks. They do that for certain reasons.
yeah, but I mean, the hardship is my wife wants it over there, and it's a hardship on me,
She don't wanna look at it. That's not a
Hardship.
But the rest of my,
He's
but
probably
if the rest of my
right about
property
that.
is not usable, and that's the only spot.
Well, he's the man that would
Well,
answer
then,
it,
yes,
yeah.
that would be your hardship, where it's I think Jessica, you said where it's, how unique is your property, and part of its uniqueness could be where it's all wetlands over here, there's a steep slope over there, there's some bedrock over here, that's the only place I could put it.
Yeah,
But that's
For
not the
this
case.
example, I got a septic system and then a cliff, so
Right, right,
this is the only place.
and that sets you apart, that's different than your neighbors who have
Right.
easier time putting
Well,
it.
and then the other thing is, we had a case come up here, someone wanted to expand on their house, and their hardship was they were gonna adopt a kid, and that created a hardship, and they needed the room for the
That
kid.
case got overruled, it was the one where it was an older, woman, and she wanted to put an addition on, cause she wanted to have a bathroom downstairs, she was gonna not use the upstairs anymore for herself. And that case stood forever, where the judge was like, no, that's a valid hardship, she had every right to have that extra bathroom, and that's the only place she could put it, so that's her hardship. But then the case from 5 years ago, the Supreme Court says, nope, that's personal, maybe you gotta move.
Well, that's what, my
Yeah.
thing with the kid, don't adopt the kid.
Yeah,
Don't
but
adopt it.
you can't, but that's discriminatory.
Yeah, let's put that
the
on the
Grinch.
tape. How about that?
What if we're having another
Right.
kid?
But
Well, if
wouldn't
you
that
have-
be discrimination if you were to say,
You
if
could
that
never
was
say that.
said
I
that
know,
in
'cause
a
that's,
meeting?
that's a,
You can never say
I think
that.
that'd be up to the adoption age.
that was,
Right? I mean, geez, that's
a
if
choice.
there's not enough
Well,
room for the kid.
Why is it not enough room
Cause you
for
could
the kids?
move, you could, maybe you gotta
They can
buy a
move.
bigger
yeah,
house.
this whole
Yeah.
story was.
Well, I had that
The
very
house was
same
too small,
instance
they needed
happen
another bedroom
in
or something.
Lake Garda. I did
We
an
all share
addition.
the bedroom.
And
Yes.
they were
Nobody
right
had
on,
their own room. My
it's
sister
not a
did.
lake, it's a swamp, but they call it Lake Garda.
Oh, yeah, it's beautiful.
And the house had the frontage of the lake, they couldn't go to the right because of septic. They couldn't come forward because of the lake setback.
Okay.
They could go to the back, and it was just 9.2 something square feet that encroached in the setback.
Mhm.
And that's what they did, they adopted 2 kids. And I had to go before the town of Farmington and appeal it, that to put on this addition, because they adopted 2 kids, they already had 3. They had 5, and they wanted to put 2 more bedrooms on the house. And it's like, you can't say to somebody that you can't make your family bigger. And my argument is look, they love to stay in the town.
Right.
They're happy, they don't wanna disrupt their kids. You know, it's not a financial thing, they could afford to go buy another house, but they wanna stay where they were. And the hardship is that this 9.28 square feet would hold up the size of the structure. And the first thing they said, well, can't you reduce the structure? I says, absolutely we can. But then doing the garage that's underneath, you couldn't even park a Hyundai in it. So now it becomes useless.
Well, that's what, you know, and then we can probably argue it all night, but if I was gonna be the devil's advocate on that, I would say you should have checked into this before you adopted two kids.
Yeah, but that's different.
It's cold, but that's the fact.
No,
You-
right.
You know, it's self-inflicted.
Well, I guess it is, but I mean, I think that I'd find that be discriminatory,
How many,
in my
how much
opinion.
square feet is this house?
Well, it was a raised ranch. It was only
Yeah.
1,850
That neighborhood's not
square
big,
feet.
big houses.
Oh, that's a
Yeah.
small house.
960
Yeah.
square foot.
That's-
When I was a
Five
kid.
kids.
Not anymore, that's,
7 of us.
that's-
Not kids, but you know what I mean.
that's how my street is, where they're all
You know,
once
I-
little capes, now they're all, you know.
Well, if you can't
That's
tell,
a
I'm mad at my
small
kids.
house.
But here's another thing though, is with, like the Americans with Disabilities Act, if, say, one of those kids you're gonna adopt was in a wheelchair and you needed that much to get a proper access, then you get the variance.
Well, they still gave me the
Reasonable.
variance, and I still did it. I mean, they had no problem with it, and all the
Mhm.
neighbors had, I mean, we're talking 9 square feet. You're talking a 3 by, you know,
Yeah,
a
that's
pie of nothing. It wasn't, and they gave it. I mean, and once I went through and said, look, if we took the 3 feet off the garage was already at 22, it made it 19 feet. I says, you can hardly park anything in there, you know? And they were fine with it, and they passed it on that. I mean, if I went in there financially and said, oh, well, they don't wanna move because, you know, they don't wanna buy a bigger house or whatever, I mean, then there wouldn't be, but, you know, they were adopting 2 kids from China, you know, bringing them here to give them a better life and everything else.
Right.
It was kinda like, you know, for you to say that, I understand, but it's a
They're on their
hardship,
way.
your family's growing. It'd be no different, you know what, I think it all, cause me and Carl had this conversation, it wouldn't be any different than the fact that, look, you know, the guy went and got his tubes tied, but you know what, it didn't take, and she got pregnant with 2 kids. How could you then say, well, you shouldn't have had 2 kids? Well, I didn't plan on it. Now what do you do? So if you played that, they can't, I can't say, well, did you plan on adopting 2 kids? Did you plan on having, so you
Well, I was gonna
can't say
you could-
that.
Yeah, you could,
You know what I mean?
we could argue that, you know, all night, you know, 'cause like. it
So,
was-
I mean, I would think that you're gonna be humane about it, and at least I would be, and I'll have you fight that battle for me, I don't know.
But you know, it's the same hardship test whether they need, you know, 10 feet or 10 inches. And that's the hard when someone comes in and say, my contractor, he built, you know, an addition to my house and he went this much over.
Oh, my God.
And you still got it, it sounds pretty personal, you got it, yeah, you
So
got
on that.
New York, state of New York, they have what they call, you know, like a de minimis variance, which is the lower standard to allow for little mix-ups where you're a
For
foot
errors.
over, you know.
So on that note, so when there is a self-imposed hardship, you build a house right on your setback line, and then you need to add a porch because you need to access your house.
Right, yeah.
It's a safety issue. So it is a hardship, but it's a hardship that you've created on your own.
That's a problem, yeah.
What does a ZBA do with, I mean, like, that's like an extreme, like, do you tell them to tear down their house? Do you tell them that they can't, like, that's,
Well,
like,
you,
what are their options in, this particular,
there's
like,
no
something like that?
hardship. If there's no hardship, they have to deny it.
Well, it's a hardship because it's a but it's a self-created.
Self-created hardship. Now, again, if it was an ADA issue, you know, where there's a disability involved, you know, then you have to make a reasonable accommodation, which means you kind of give them the variance so they can get in
Yeah,
their
if
house.
you.
But if they're able-bodied, they could get in some other way.
Well, I don't
Yeah.
think, building code wise, I think you need a porch or some kind of
Little
steps to get
something or
into
other.
your house, so they're never gonna be able to use a house, you know, like, in such a scenario, I feel like, unfortunately, the ZBA gets backed into a corner on
Yes.
something like that, and I was curious as to how they should,
But
like,
don't
what
most,
would your recommendations be?
Well, if it's self-imposed, self-created, you have to turn it down.
Turn it
And then
down,
unfortunately, it gets
right.
back to you guys, becomes an enforcement issue, and now what do you do? And maybe they can buy a little strip of land from their neighbor, who knows?
now what about,
Yeah, we're kind of boxed in on those. It's too bad there's not some
That, I was just curious.
way to work around that, except unless there's like a disability somehow, if they, you know, if you could kind of, yeah. I know.
Get a 32-ounce estimate and take out their leg. Now you got the ADA, you can get it.
Got the kid.
Right.
Well, don't most towns adopt now to where you have to have an as-built before you can even continue framing after the
More and more you're
foundation?
supposed to, but some, it's not
We
always
don't
done.
do it
It's
here,
not
I
always
know
done.
that,
You
but.
can, our regs make it so you can ask for those kind of like as you go, but for the most part, we don't have a lot of reason to.
People are smart, they do it, but
Right, cause
You
this
know?
way, now there's no, everything ceased until you
you just
have
catch it
your
early
as-built.
and, but some people just cruise, they just build it out and then, you know, they hope for forgiveness later kind of thing, you know?
Yeah, cause then that reduces the factor of any error, you know, after the structure's already all the way up.
It would.
I mean, there's a lot of towns that do that.
But
I mean, do you have to, is that something that you would have to then go through zoning to do a regulation change on, or that can be just implemented?
the only time I've seen it is like commercial, sometimes you'll put it as a condition of approval kind of thing where they walk through it. But there's architects involved and everything else, lots of professionals. Single-family homes are permitted use, there's just less oversight, if you will. And that's why you get this stuff where they're over 5 feet or something, you know?
I would even think the banks under new construction would mandate that.
I know, to protect their
You
investment.
would think that it would be by default, that they'd say, okay, we're not releasing any funds until we have an as-built
But if
that
it
shows.
sneaks by, is it 3 years? If it sneaks by, then it's a legal nonconformity,
Really?
yeah.
And that's basically across on everything?
On a building, if you build it and it's within a setback or something and no one catches it for 3 years, it's a legal nonconformity.
So it's only building, so it's not like if somebody does an
They added
apartment
decks, no, they
or
added,
something in a house.
not a use, it's just the structure.
Okay, all right.
The use is never, if it's illegal, it's illegal forever.
Gotcha.
But that's why, it's to protect in case, you know, you have all these buildings in town that the people just never got caught somehow.
Even if they never got a certificate of zoning compliance?
I think that would be the.
No, I think once they show they built it, you have to catch them.
No, but I think you're caught then, if you're asking for a certificate of zoning
Right,
compliance and
yeah,
you're not
absolutely.
getting it.
Unless the
then
guy's in the basement,
that
just like,
makes
hey,
it-
whatever, you know, no one's
Yeah.
checking it.
So if someone builds a house illegally and no one catches it for 3 years, it's all right?
Legal non-conforming, just as for its location,
Yeah, if it's built into the setback or
Yeah.
whatever.
right, just for
Really?
location,
3
yeah.
years?
3
That's it?
years, that's it.
Right, you can't just buy a lot and not go before the board and get any permits and build a house and after 3 years say, well, you guys didn't catch me building it. 3 years, it's already, right? I mean,
Just the location, where
right,
it's
it's just the
stuck, it's
location of
okay.
it, yeah.
Hopefully a neighbor
That's
turns
what
it,
I'm
if it gets
saying.
too close.
Yeah,
Okay.
the location on your property, if you go buy, build something, so.
But if you sneak out, yeah, put a little, you know, garage or something back of your house, you know, it's way in the rear yard setback or a shed, yeah, it's way, that's often what it is, what's a shed, like right up against the, but the neighbor doesn't care and no one calls, so. But my sister-in-law put her chicken coop way in the back, and I said, oh, 3 years, you're all good.
Why do you need to get for zoning on a chicken coop?
For a building, where she's in, I won't say where she is. If it's a building, structure, well, it's in a side yard. But yeah, I don't think you need a zoning permit, but if it's in the side yard, you gotta get out of there.
It's the same as a shed.
Yep,
Yeah.
you can't put it in your side yard.
I had somebody come to me and they said
We never get applications.
No.
they had built a shed, but it was actually not on his property line. It was kinda like a couple of feet off his property line. He said after 17 years, if it wasn't, you know,
Oh, that's what, adverse possession,
yeah. is that-
15
Is
years.
that true, or is that just
That's
a?
squatter, if you put your shed like on your neighbor's property and it's there for that long, that becomes your property.
Yeah, but isn't it maintaining though? You have to show that you're maintaining.
Well,
the
yeah, if your
property.
shed's on it, you're kinda, you're laying claim to it by putting your shed on it.
All right, here's a good question for you, because I'm personally involved, have this scenario.
Can't do per,
My right of way as it goes into my property, the neighbor, they bought their house, I'm gonna say now about 11 years ago. I bought the property, 6 years ago. Their driveway encroaches into my property on my right of way. It's not a terrible amount and this and that, but when does the adverse possession start? When they repurchased it, or from the original person that put it into my setback. So they bought the house 11 years ago. If the clock starts ticking when the person did the actual modification, or again when they bought the property?
Modification.
That's a good question.
Because,
I'm not gonna-
I mean, I should be sending a notice then, because it's gonna be coming up close to.
At some point, you can always just, yeah, stick your flag in the ground and say, no, this is mine. And that's all you need to do. So if your neighbor puts your shed on, if you just knock on his door, send him a letter saying, hey, your shed's on my property, that restarts that clock.
Okay,
So if you're curious how many, that's the safest way. You send them a letter saying, I think you guys are on my land.
well, how can you prove that you sent the letter? You'd send it certified then. It would kinda, that might rub your neighbor a little bit too.
That's the thing, I know, right? You gotta keep harmony.
Currently live?
Yeah.
You really wanna?
I know, stir up the pot.
No, I know. No, not him. No. I'm waiting for him to,
Yeah, I haven't heard from him recently.
no. Well,
I don't remember him.
yeah, we'll keep, no, it's the neighbors you pull in on the left. They're great people, I mean, you know, and everything, but their driveway and their property, their bank actually goes on my property quite a bit. I mean, I would have to probably say about 30 square feet of it. But I just, you know, my thing is I wanna know, geez, cause they bought the house the way it is. Does that adverse possession start from when that person put the driveway in? Or does the clock restart when the property is resold? So let's say they bought it, the guy did it 4 years, a total of 15 years ago, but sold the property 4 years after he did it. Now these people had it for 11 years. Does the clock restart when the property changes hands again?
Right?
Or does it from the time that it was actually done? I think I'm gonna be sending a letter.
That's the safest and cheapest, yeah.
Yeah, and I'll approach them, they're reasonable on it, and I mean, it's,
They are now, but,
yeah, I know. I just have to give them more chicken eggs
you're right, there you go.
from the chicken coop
Coop.
that I didn't get a variance. That's all right, the barn was already there.
3 years, I hope.
It's been 4.
Dealers and repairers licenses on page 25. You don't have to do public hearings on those again? There was,
We only had 2.
Safest way to do it.
well, they said you didn't have to, but now they just re-decided the case and now you are
They
supposed to.
did.
Yeah.
When?
Oh,
Like that?
like this year, like, yeah, it was recent, super recent.
And what is that? I missed what the,
Oh, for like a dealer's repairs license, so, you know, a repair shop,
Yep.
auto repair shop. It's, you always were supposed to have a public hearing on those, and then the court says, no, you don't have to, but now there's been a new decision saying, yes, you need to have a public hearing. Cause a lot of them are just, it's weird, 'cause with those licenses, if that business is sold to a new owner, that new owner has to come in before you and get,
okay,
which kinda,
even though it's already existing?
even though it's, yes, that's why they
Because we
keep,
had 2, well, one of
I
them.
saw this with Hein Brothers.
so to make them go through a
All right,
hearing,
we did have 2, because we had that, and then we had the old Corrigan that he took
Yes,
in
Willie's.
right next to Laurel's.
Yes.
yeah.
And he came in on that too, as far as it was already in existing, and we just waved it through.
That's the thing, so that's why they thought, well, maybe you could just do it at a meeting, cause it's just, a lot of times it's the same business, just a new sign
New
going
owner.
up or something, new owner. But no, they want you to do the hearing, so you gotta do the
So they have
hearing.
to do a whole application and everything again?
Public hearing and notice it, all that stuff, yeah, I know. And, and when you make your decision, some boards make the mistake, you know, it's not like a hardship finding or anything like that. Basically, you know, you're functioning as an arm of the Department of Motor Vehicles. All on those applications, you're just looking to make sure that that location is still suitable for that business. It's still safe for them to come and go and that sort of thing. So conditions have changed. I guess maybe you could make them improve their driveway or something, or their access.
Really? Even like the access ways, everything?
It looks that way. I mean, we're supposed to, that's what we're signing off on. It's a safe location, so.
So that's the question you have to ask yourself before you granting them the
Yeah,
approval.
yeah, it's still a good
Is
spot
this-
for it.
So a perfect example would be if they put a Walmart or like a CVS across the street, which now increased traffic flow, where prior to that not being there, it was safe for people to enter and exit that facility. But now that that CVS is there, there's an increased traffic flow, that entrance and exit is not suitable. You can actually now say to them, they need to change that, even though the prior person that's been there for 50 years sold the business, identical business, and built a new facility, and this new person is coming in, we would, as a town, be able to say,
If it's a continuous use, I think you'd be hard pressed to, turn them down, because they'd have a track record. No, it's been there, it's been a continuous use, no traffic accidents. The one thing I had, it wasn't Bantam, where it was, repair shop and gas station had, closed, and was closed for like, 10 years. A new guy comes in and wants to reopen it. Well, 10 years had gone by, a couple of new restaurants had opened up, it had changed. So you had that break, that stoppage of use. So there they were able to say, no, it's not safe
but
anymore.
I'm saying in this instance,
In
if
that
within
instance-
2 years, the CVS went in there,
Yeah, but you still have a continuous,
and you have a track record, okay.
track record.
I just wanna be clear, because that's
I
pretty
think it comes up where
serious.
it's been abandoned, like sometimes these gas stations, because they're leaking fuel, they're shut down for 10 years.
Right,
And then some new outfit comes in, they wanna reopen it.
okay.
Then I think you could look at it and say, well, it's, lots happened in 10 years. But if it's continuous operation, yeah, I think it is, like you said, it's almost like a rubber stamp in a way, where it's like, it's the same business, yep, same operation, yep.
Okay.
Alright. I guess you guys get junkyards, they're recyclers' yards now, not junkyards anymore, so.
Yeah, but there's pretty stipulations for those now. I mean, you can't just go in anywhere. I mean,
Right,
Exactly,
I
those are,
don't think we'd ever see that ever come to play in this town.
probably not.
I would think, no.
First off, there's really no place to put something like that, I would think.
Yeah, plus if there is one existing, when I've had an issue with, we tend to kick it up to the state, the DMV,
Yeah,
because they
you got
regulate them heavy duty.
Concrete pads, you gotta have
Yeah.
runoff and all that. I mean, that's huge.
Mm-hmm. Yep. So, I just thought the dealer's repairs one was the one I wanted to bring up. Yeah, 2021, it's on page 26, 1 Elmcroft Stanford LLC versus EVA, 2021. So it's just this year. Gotta do the hearing. I don't know if you guys ever get interveners, not so much here, right?
Not in my time.
Yeah.
What little Lord have to say,
That's the man. But if you ever get an intervener, you give them the same rights and, as the applicant to make a little presentation, but just for environmental stuff. Alright. Well, how do we do? Is there anything else, or? Just going through quick. Because you guys can do what they call like a pre-application meeting too. I mean, you guys probably handle a lot of that stuff too, but if someone wants to, they could actually come before you, if they get on your agenda, but before they filed an application, they could come and informally just throw an idea out. And you could informally, give your opinions on it. And the court has said those opinions can't be held against you later, so you can freely speak your mind. So if someone comes to you and says, I'm thinking of applying for a variance to get a pool in my backyard, but it's gonna be in the side yard and this and that, and, you can feel free and say, well, we need to see a hardship. That's when you can maybe give them some advice. We're gonna need to see that hardship.
Really? So
Yeah.
you can in turn steer them to how
At
to
the
get it
pre-app,
approved?
usually it's like, staff, these guys will kind of warn people, like, you better have a hardship. If you don't have a hardship, they're not gonna.
You have to have a hardship to put a pool in?
Yeah,
Okay.
If you're going into the,
in the side yard, yeah, if you're gonna go
if you're
in.
going into the setback, right?
Oh,
But again, suppose it's like an ADA issue where someone, for physical therapy needs
right.
a pool, there you go. Then the ADA, you have to make a reasonable accommodation, which would probably mean given the variance within reason,
That type of variance does not run with the land, correct? An ADA variance?
That's a good
It
question.
goes away.
'Cause that's so
It's my
personal.
understanding it
Right,
goes
like the
away.
ramps are.
Yeah, the
taken
ramps,
down
that's
once.
true, the ramp, a pool I would say, would you really, put it in
Well, right,
ground,
Yeah,
but the ramp would definitely, you're right, that would go. It's a personal variance, yeah. Even though it's recorded, they would record it.
right.
Now, if someone else bought it and they had a need for it, and I guess they,
Also, when the person that requires the ADA is no longer there,
that's what we're saying, yeah.
that exception then is no longer.
Correct, yeah, yeah.
So what happens then with, here's an example, with the front stoop?
Theoretically, it goes, I guess, right?
Mhm.
Who's gonna? But now if it's been there 3 years.
And nobody said anything.
Well, but if it's an ADA variance.
Right, does it stop the clock on that? And then when the person moves out, how do you know when they move out? And then the clock starts running, I guess.
Somebody would have to complain, right?
Yeah, well, that's how it always is.
Yeah.
They always feel like, how'd you find out? It's like someone complained.
Yeah.
Well, I've had it where somebody just recently listed their house and they finished the basement. Well,
Yeah.
let me rephrase. They bought the house from somebody that finished the basement. They lived there for 7 years, got divorced, and then when they got divorced, they're selling the house.
Yep.
And they put it as more square footage on it. And actually, the town clerk must scour all the real estate things
Sure.
and found that the square footage wasn't to what it was. And actually made them come in, the town come in to inspect and do everything. And then they also had to do a tax adjustment and it was
Oh
like.
my gosh.
They
Nightmare.
really put a stickler to them on it. It was like, they don't have anything better to do. They're scouring realtor listings. That's crazy.
Some people do it for trying to catch the Airbnbs. They'll go on VRBO and find out who's listing properties in town.
That sounds like the ex-wife was trying to get at the.
Yeah, it possibly could have been, yeah.
Get mad.
To me, I don't understand, I think a lot of it is to me, regardless, if you have a 4,000 square foot with 4 members and a 400 square foot house with 4 members, to me, I feel, in my opinion, I don't know how anybody else, I think it's discriminatory to charge people more taxes based on that they generate a larger income. What difference what services are you providing that's grander? It's still a 4 members of a family and 4 members of a family. What difference is it on the size of the structure? To me, you're discriminating against me for making more money and wanting to live in a nicer home. It should be done, to me, is by the population of the town. The town costs $10 million to run, and there's 10 million people in this, everybody pays $1. That's how I would think it would be,
Yeah.
that's how I feel about it. So a lot of these
Easy.
regulations, I struggle with having to enforce, in my opinion. I stand by it, but I do what I have to, but
Right, it's good you're here, though, give that perspective, because sometimes they do some work in Durham and half the board are like Wesleyan professors with no real-world experience, and they're and they want to be, they want to be the smartest guy in the room, too, so. It's nice to have someone, who you deal with this stuff, so. Page 24, I never get to cover this, special permits for ZBAs, I never get to. It's very rare. Zoning commissions are jealous, they like to maintain it. But character's a bad word now, we have to get that out of there. I'm not sure what to do, but.
Working on it. We have an interview with Brian Miller, the zoning.
Brian,
That's
yep.
you recommended him.
Yes, I did, yep.
Yeah.
What is this now?
What word?
The wording? I remember we had a topic of this, but I
The
can't.
zoning commission is going to be, we're not calling it rewriting, it's more like a reformatting and a restructuring of their zoning regs. It's a two-phase project. The first phase is basically cleaning them up because they're not very comprehensive. So, and then once the POCD is complete, probably in about a year from now, that will be incorporated into the new cleaned up zoning regulations. And at some point, in a few years, we'll then do the rewrite of the zoning regs.
But that's
So,
the,
but they are gonna incorporate the new legislation and remove character.
Right, so what words are they saying? Why is it that they're removing the word character, though?
It's- because it's,
I'll let you explain that one.
it's code for keeping certain people out of town, I guess, or something.
Oh,
But what is the word? It's supposed to be based upon specific, like, architectural standards or something,
Yeah.
so, you're gonna need,
I would never think of it like that.
Well,
but you
we're
can still use
saying
harmony, you can still use harmony, and you
Right.
can still use,
The character of the neighborhood.
no character, can't use character.
Right.
But harmony, protecting, can you still do property values? I'm not sure about that anymore either. I don't think you can't do property value, that's the bedrock of zoning, is property
Parts of
values.
it, yeah.
So it's harmony, and then you're supposed to, but sometimes it depends where it is in your town, cause if it's in like, a town center or something, you actually is easy, you know, it's all Victorian style or a Queen Anne, or we wanna keep that look.
Right, yeah.
Well, that's what I would think is
Yeah.
character.
So you can't use characters, so instead you have to try to describe what
I
is
thought it
there.
had to be well defined. the
Well,
character.
that's why I
If
thought I
you're
was
gonna
worried,
build-
like a form-based zoning or something.
Right, if you're going to base it on character, the regulations have to state what that
Yeah.
character specifically is.
Yeah.
Well, that's,
It
I
can't
agree
be
with
a
that.
arbitrary
But you
kind
can't use the
of
word character.
personal judgment on it.
Mm-hmm,
But you're saying you can't use the word character though.
right.
Or you have to define.
Or you
Define
have to
what is the
specifically
character.
Well, you have to
what you mean.
define character, okay, so that's, I'm all right with that.
The regs
The
should
regulations,
have
yeah.
to define it.
And where did that come from?
There it is.
Legislation is.
It's the physical site characteristics of the district. And the regulations must have clear and explicit physical standards for
So
site
that
work.
was a bill that was passed or something?
Yeah, what we were dealing with last summer, yeah.
Okay.
Yeah,
Cancel culture,
so,
in essence, I mean, it's, everything's becoming discriminatory,
So,
no matter you, it's.
now your
Yeah.
regulations are gonna be about, you know, this
That was
thick.
on your-
Yeah.
I thought maybe it was like that form-based is where they kind of, you know, like Simsbury adopted all this stuff where they do try to break down what things should look like, if that's what we're gonna end up having. But I guess you have an architect describe it. What's in Farmington, we have the village districts kind of thing too, where you're trying
We
to
have to do this.
describe a look. But they really don't even go this far, I think. It's more, I don't know.
It's kind of ambiguous.
Right, and it's like, why is it getting so analytical on a word like that when you're just trying to describe, I mean, it's not like you're casting insults or anything, it's your.
Right, right.
I think that's the way they're interpreting it, though, is,
You mean the word character?
It takes away a lot of your
Right.
authority, because then
Well,
you're left with just trying to, of having what you're, because a lot of developers will get frustrated because they could meet your specific requirements, you know, how, where the building is, how tall it is, and, you know, and even what it may be, what kind of, you know, appearance overall, but, you know, when you can turn it down on character, it's hard for them to,
Yeah, I could, it's not like
Yes.
saying, well, this is a historic district,
right,
but because it's,
but it limits
Yeah,
your discretion, because sometimes things don't what they're proposing, it's too big in scale kind of thing, where it just doesn't fit, you know, so.
So you have to just say it's not in harmony then.
I think harmony's still okay, right?
I think so, I don't.
Because that's what I saw. It's like, all right, take character.
feel
I'll
for you.
have harmony. They can
I
use.
feel
It's
for
not
you
in a
because I
harmony.
want to go through that.
That's just.
well, I
I
remember
really
though,
do.
when my husband and I were first looking for a house, a new subdivision or something, and we just threw out there, well, what, maybe, but maybe we'll put a, log cabin, and they said, no, you can't.
Yeah, it doesn't fit. Yeah,
So, that would be character, right?
that's character. Yeah.
But in this case, no log cabins to go with.
I guess it could be a specific requirement. No log
We
cabins
don't
in
like the
South.
character.
So anyway, that's, yeah,
Sorry to hear that.
it is because that's why you did
There are
special permits.
bigger fishes to fry, that's nothing. I don't know why they're bothering with that, that to me is ridiculous, waste of time.
Mm-hmm. I know.
Well, maybe because it's not defined.
That
So
was
is
with the
it-
developer, and they had the ear of the legislature, the other home builders and developers, where you, right, it's not defined. If it's specific, they can come in and just say,
Right.
well, okay, this is
All right,
exactly.
so I have never thought it other than the character of the town being like a New England town where it's old-fashioned looking. I mean, I would never think of it in any other way.
I know, but
other
even,
than that.
even using that interpretation though, what does that mean? What you can't build or what you can build? You know, it does, it's just not well-defined, I guess.
I guess you're right. Yeah.
But the classic special permit it uses was like, say, like a church,
Right,
where with the special permit idea was that, well, while that particular use could work in that zone, it doesn't work everywhere.
right. Right,
So by making it a special permit, you could say, well, it works here, it doesn't really work over there.
yeah.
And with character, allowed us to kinda allow in certain uses,
I gotta go to.
but have control over exactly where they went and kinda thing, you know?
I remember when I was living in Wallingford, I lived on the corner, well, where 68 and Highland Avenue cross, you know, there was a piece of property there that they wanted to put a small church, not, you know. And somebody came in complaining about the wetlands because they thought that property was wetlands. But then it was just like, they complained about traffic and everything. I mean, it was gonna be a really small church. I don't know what to use it as an example, but the funny thing was, my church, the Catholic church, that was pretty big then, lots of parking and, you know, on the same road as the schools. Nobody complained about that big church being there. So I don't really,
Yes,
I just,
raise an eyebrow and
yeah, right, they just.
someone else comes in.
Yeah.
I have a question that we had. It's, in regards to a situation to where, the town had widened a road, which decreased their setbacks, which put a structure further into encroachment. The structure was damaged. Now, there was nothing on the deed stating anything, but when you pulled the plot plan of the structure, it clearly stated on there that if this structure ever became to a certain point of being destroyed or whatever, that was irreparable, it would have to be demolished and cannot be rebuilt. Lo and behold, somehow, some way, it did get rebuilt. Where is it that clause, even though it's not recorded on the deed, if it's recorded on the clerk's plot plan and recorded into the town, and it's not handwritten in, it's actually done on the, let's call it Mylar, but on the plot plan,
Right.
and it's done as with all the rest of the type, does that consider to be law? Or is that, because it's not on the deed,
Right,
have-
private.
I would say the
Restriction.
deed.
It's on the plot plan.
Yeah, it was a note added in.
in the notes, it wasn't handwritten in either.
Okay, like,
It would be like, sometimes how resolutions require notes to be made.
yes, on the map and
Yeah,
making part of their approval.
right.
Because if it's part of the commission's approval, then that's enforceable by the commission.
That's what I was saying, but,
Would they make you take it down?
well,
boy.
theoretically, a big huge tree that was about 4.5 feet in diameter fell on it. And theoretically, the applicant came in and said it had to be torn down. We didn't put anybody out there to verify that, but the applicant stated that it was too far gone, that they needed to tear it down and rebuild it, and since they were gonna do that, they wanted to push it more into conformity. But the thing is they had like 5+ acres that they could have rebuilt that anywhere on their property.
So we denied
We denied
it,
it,
we denied it.
but the thing is, it's rebuilt, and it's rebuilt in a position, I don't know how it happened on that, but it is a concern amongst a few board members on how that happened, because my feeling was is that even though it's not recorded on the deed, it's not like they were out at the lot and they hand wrote it on there and then recorded it. It was actually put into the notes and recorded with the town. Now, I
Right.
mean, I would think that once it's recorded with the town, that becomes an enforceable document. That's regardless if it's not on the deed or
Check
not.
the
So you
minutes too,
mean
if
they
they're-
rebuilt it?
It's all rebuilt, yeah, it's all rebuilt.
Yeah, you're talking about Kettleton.
I don't wanna say anything, but,
Okay.
Well,
Yeah, well, that-
General.
you remember that one.
Yeah,
yeah, let's not bring up any.
Okay, well, I'm not saying names, but I'm saying,
We're doing a hypothetical here, so
that
Okay.
my thing
hypothetical,
is,
that hypothetical barn wasn't that destroyed, but, yeah, it's, the new one's back there. I thought we took care of that. I thought it was okay for them.
I,
Hypothetically, he did it.
Yeah, but not through, we declined it. It
Well,
was
don't we
not
have-
approved.
Then we can sue them.
No, let's not get into, we're not looking to point fingers. I'm asking, all I'm asking is where is it enforceable? I'm not asking to revisit and figure out, all I'm asking is where is it
All
revisitable?
right, so what do we do with it?
There's other circumstances surrounding that, and at this moment, I really don't remember.
Yeah.
No, I'm not looking to, we're not looking to assign
All right,
anything.
so what do you
We're
do
just-
with a scenario with
situation.
that?
What do you do? Is
For a
that
teaching moment.
enforceable? And I believe
I
you
think I
said
checked the
yes.
minutes too, just to make sure everything lines up where those were somehow conditions of approval. And if they are, yeah, normally they're put on that
The-
plan
The
and that's
block, the
recorded.
index block.
Then that's enforceable, it's like a zoning, a violation of a zoning.
Regardless
regulation.
if it's on the deed or not.
Exactly,
Okay.
That was,
Oh,
but we need to double check to make sure it actually was,
Okay.
that was very old, I doubt we
I think
have.
it predates a lot of,
records,
yeah,
minutes.
so it would be tough to recreate that
Yeah,
record.
But I mean,
Cause if it's a
would they-
private agreement, then we don't enforce those, but if it was part of that approval process, then the town and the commission can enforce
The
it.
way that I gather it, and this is only my hypothetical on this, is that when the road was widened and the property was taken,
Mhm.
so let's say there was 10 feet from the edge of the road to where the corner of the barn was, and when they widened the road, it's only 2 feet. There had to be some type of monetary, I would imagine, or whatever for that land swap to go to the town to make that road wider. But then they also, what I would think would have said, okay, well, we're gonna give you X amount of dollars for this property, we're getting closer to the barn. Now, if anything ever happens to that barn to where it
Right.
comes to a point that it's not, it's so badly damaged it has to be torn down, you cannot rebuild, and it was written into that. And so once that becomes the issue, to me, regardless, if, especially when the applicant comes in and says, this thing is so badly damaged, we gotta knock it down to rebuild it. We didn't say that, he did. And, now all of a sudden, apparently it must have not been that badly damaged, because now all of a sudden it
Yeah,
got
it's
rebuilt.
back up.
So I just wanna know from going forward that if that's the case and it's on that plot plan, that's enforceable.
Well, I'd feel more comfortable if there was more backup, just to make sure it was.
Right. And like I said, I'm not looking to associate it, I just wanna know my standings, that if I, in a meeting and it's like, no, it's on here, that somebody can't say, well, no, it's not on the deed, that's not true. I can say, yeah, it is, and I think we need
Yeah,
to,
cause the deed would be more, that's a private agreement, if something's on your deed, that's a private enforcement issue.
okay,
But it's on a town document, so recorded like that was a plot plan
all
or
right, thank you.
plan, but you wanna make sure though, just to make, I don't know how old it is, like you said.
So
how
it is,
old we have.
it's enforceable
It's
then.
enforceable,
Yeah.
yeah,
yeah.
right,
Cause that hypothetical barn, has a whole new foundation.
right, yeah,
Wow,
It's a whole
and
new-
it's moved,
It's a new building,
Yeah.
yeah.
whoa.
Could they
Hypothetical.
make it,
new
but I
building.
mean, would you make them take it down? Is that what-
It's an extreme remedy, but.
You get hypothetical pitchforks and torches and we can,
I didn't say that,
it's hypothetical.
no.
You guys got half your training done, how's that sound?
Good.
No, I mean, there's a lot of things that really, it was 2 hours, which I don't know if I could go all night.
And it sounds, I know.
No, not me either. Yeah.
I got no kids, so I can go all night too.
Okay.
Should I send I could send a little certificate or something for these guys,
yeah,
keep track of it,
yeah, that would be great. We were gonna start like a spreadsheet and start,
that too, why not back it up?
but yeah, if you wanted to send, we could be your guinea pigs, you can bring the first certificate or
Right,
What's
right.
that?
Just to show that you guys did 2 hours,
whatever's your training.
they could do a little certificate or something.
Yeah,
that would be nice.
The commissioner training.
That'd be cool.
Yep.
I'm sorry?
You remember we talked about the commissioner
Yeah,
training?
yeah.
Yeah, you guys did 2 hours,
You're halfway home.
Oh, this will count towards that?
Oh, yeah.
Oh, okay, all right, cool.
So I think you have to motion to adjourn.
Oh, okay, yeah, any motion to adjourn?
Motion to adjourn.
Second.
Second.
All in favor? Aye.
The meeting is
Hey,
officially
awesome.
closed.
Good to see you guys.
Yeah, it's good to see you too.
So
It's great.
we could have more of these then, right?